The first time you learned to drive a car, it was all systems on deck. You had to think about it. You had to use your vision, your audition, your every sense, and to try to figure out how to work that machine. And what happened was, over time, it became so automatic that the driving program under ordinary circumstances is now overlearned and routine. And the brain no longer has to work as hard to perform these skilled activities as it did when you first learned it. And again, that's what the brain wants to do. It doesn't want to waste any energy. Keep the simple things simple and save the really intensive brain power for the things that are unusual and more challenging.
Would that apply, for example, in playing a musical instrument?
I'm sorry, what?
Would it apply, for example, in playing a musical instrument?
Well, that's another good example. I mean, if there are any musicians in the room today, they understand that the first couple of times you tried to play something, you wondered, how could anybody now, maybe a couple of years later in your practice, and it seems like what we call second nature. Well, it's not nature. You practiced. You became good at it. It became more automatic. And just think about anything you do in life that's in that category. We do so many things automatically because that's how our brains have trained us to do it.
Would a surgeon completing surgery be another example of that?
Yeah, I mean, this is very important and very complex skills. Where this often comes up in skills such as aviation, surgery, medical skills. It's very important that if a surgeon is performing, hundreds and hundreds of operations of the same type, that some aspects of that operation are going to be routine. But the surgeon is focusing on are those unusual aspects of a particular procedure that may cause him to zero in more with that system 2 thinking and try to figure out what to do in a more deliberative, conscious, reasoning kind of way. But the only reason he's able to, or she is able to do that, is because other aspects of the procedure have been overlearned, have been well practiced, and don't require that intensive type of concentration.
Can the same thing occur with firearms training, for example?
Firearms training is a specialized skill in law enforcement. One of the reasons that we want all professionals, whether it's police officers, paramedics, firefighters, EMTs, to practice is because we want most of the things to be automatic. And in fact, if you speak to officers who have been involved in officer-involved shooting, many times what they'll say is...
The objection is sustained.
Okay. Well, stay with what other officers have told you. I just wondered if it happens in firearms training as well. Fair
yes,
enough?
It does.
Okay. All right. What's muscle memory?
Well, it's an interesting term because your muscles really don't remember anything. The only way your muscles know anything is by what the brain tells it. Your muscles are hooked up to nerve fibers, which in turn are hooked up to neurons in the spinal cord, which get their direction from cells in the brain. So the brain tells the spinal cord to tell the muscles what to do. The learning part of that process is what happens in the brain. And then when the brain becomes more efficient at a task, it tells your spinal cord to tell those particular combinations of hundreds, if not thousands of muscles, how to behave in a given circumstance, whether it's driving a car or practicing on a firing range.
Okay. What happens in the brain when a person learns a new skill, and how that new skill interacts with the old skill already learned?
Well, one of the cognitive psychologists will tell you that one of the principles of memory is last hired, first fired. In other words, the brain does not forget anything. If you learn something new, especially if it's different from, in some respects, similar to, but in other respects different from the old knowledge, what happens is the old memory, the old skills, they become overwritten. And so in most circumstances, after a while, you become more proficient in using the new program, the new skill. But there are circumstances under which the old skill, remember, it's there in the background, that may become what we call prepotent. Prepotent simply means most likely to occur under certain circumstances, and it may overwhelm the training that occurred more recently with the new skill.
Well, this brings us to a term in psychology called the action error. You're familiar with that term?
Yes.
Would you explain to the jury what an action error is?
An action error is a sequence of responses in which an intended action has an unintended effect, especially where this does not have to do with outside interference, willful neglect, or conscious manipulation. Plain language, you intend to do one thing, think you're doing that thing, but do something else, and only realize later that the action that you intended was not the one you took.
Well, are these action errors unusual in our lives?
They occur all the time.
Could you give us some examples?
Well, I mean, action errors occur all the time. Simple examples are the first couple of weeks of the new year. Many of us will write the previous year on a check or on the top of a paper. Of course, we know it's a different year. We know it's 21 and not 2020. But if we're distracted or we're thinking about something else, that old memory comes back. Other examples include if you're in a traffic circumstance and a car cuts you off. How many times has this happened where you impulsively and instinctively slam on the brake? Even though stopping may not be the proper thing to do if you have time to think about it, but that's an overlearned response. You've braked and braked and braked so many times, that's what comes to the fore. And I'm sure, we can all think of a plethora of examples in our own lives where this has happened. And again, typically they're trivial and we laugh to ourselves and we say, how could I do that? How could I be so silly? That was a silly mistake. Well, it wasn't silly. It was that old action program coming back for that moment because your attention was distracted while you were intending to do something else.
Well, another example would be password confusion. You change your password and you use your old password, for example.
Well, we've all gone through that. It's, somebody hacks your account and you have to change your password, and most of the time you remember the new password, but if you're thinking about something that's extraneous and instinctively you plug in the old password and the only thing that lets you know it was wrong is the little error message comes up, and then you go, oh, that's right, I changed the password.
There are examples, though, of action errors that occur that are far more serious than what you've just described.
Well, if we're only limited to passwords and checks, we probably wouldn't be having this conversation, and it wouldn't have been such an intensive area of study for almost the past 40 or 50 years.
Well, give us some examples of action errors that have been harmful.
Action errors can occur in medicine, where if a medical personnel are being trained on a new procedure, and they are trained just to the point of criteria. In other words, they know how to pass the test and get certified in using that procedure, but they've been using a different procedure for several years prior, and then a circumstance occurs where it's a high critical circumstance, it's one of these emergency room situations, the brain may default to the old program. And these have actually happened, and the medical community takes a very active interest in studying this because obviously the goal is to prevent this from happening.
But yet it does.
It does occasionally, yes.
And how about in the fields of military, nuclear energy, aviation? Does it happen in those areas as well, and if so, how?
Probably the industry with the largest record of studying action errors is the aviation industry, because here, if a mistake is made, we can only imagine the tragic consequences. And there have been circumstances where, in a cockpit, personnel who have been trained in a procedure or in a particular type of aircraft, and they've flown this aircraft maybe dozens of times, but have flown previous aircraft hundreds of times, or maybe even thousands of hours of flight, in a very high-stress circumstance, which involves the safety of everybody aboard that plane. They will reflexively default to the previous action pattern, and it's an error because that causes the plane to lose an engine and in some cases to crash.
During an action error, I think you touched on this, does the individual involved realize that the error is taking place at the time it's taking place?
I'm sorry, could you repeat that, please?
When an action error occurs, does the individual who commits the action error understand that the action error is taking place when it does?
Well, that's what makes it an error. During the action itself, the person thinks that they are performing one action when they're performing something else. Typically what happens is when the intended result does not occur, they realize the action was an incorrect one. But while they're doing it, they think they're doing thing one while they're doing thing two.
Okay. What are the critical factors in the literature that contribute to action errors?
Again, as they've been studied in aviation, in medicine, the nuclear power industry is another active area where this is studied. There are three main factors, and that is hyperarousal. The person is under.
What's that mean?
That means the person is under an extreme degree of stress. But what's interesting, it's not the arousal itself necessarily that causes the action error. It's the other two factors that are associated with it. Like hyper distractibility, hyper focus. When you are in an extremely emotional state, you zero in on the thing that seems to be most dangerous, most critical. And because you're zeroing in on one particular aspect of that situation, the thing that is causing in your mind the greatest peril and danger, you're tuning out everything else. So you've got hyperfocus caused by this hyperarousal. And of course what that means is you get the third factor, which is a distraction of attention. Because you're zeroed in, you're tuning out everything else. And if you look at almost all of the action errors that occur, especially the ones that have been studied, and they've been studied because they've had a tragic outcome, it's these three main factors in various combinations that are responsible for the unfortunate event that occurs.
When you talked about the factors, is there a relationship between System 1 and System 2 thinking that is involved in those reactions too?
I'm sorry, could you...
Is there a relationship between System 1 and System 2 thinking, as you've described it, with what you've just described as the critical factors?
So again, when you're performing any skill, you're operating mostly on your System 1 thinking. Most things are automatic, most things are routine, and you're keeping System 2 in reserve just in case something unusual happens and you have to sort of tune in and concentrate a little bit harder. And that's how it works. You know, when you're driving a car, flying a plane, performing surgery, there are going to be some aspects of it that are very routine and common, and there are a couple of things that you need to use your brain on. You have to change a route or stop because a car stops in front of you. But if it's a high-stress circumstance, extremely high arousal, what happens is that System 2 then gets knocked offline. It's not there to overcorrect for the previous System 1 action error, the previous overlearned response, which used to be the right response, might have saved your life in the old situation, but now, in fact, is superseding the more newly learned response, and that's what's taking something that ordinarily would have saved your life. Now it's putting your life in danger.
There's a phrase that I've read in your books, it's not the object, it's the action.
Well, a lot of times, you know, people say, how could you not know the difference between this particular object or that particular object? And in the example that you raised before, in firearms, how could you not know the difference between, let's say, what a flashlight or a baton or a taser looks like and a firearm? And these are all objects that have been confused with a firearm in various cases. So the point is, it's not the object, meaning there's nothing wrong with that person's perception. If you put the two objects in front of them, they can easily tell the difference. But the perception isn't working. It's offline. The program is not running because the previously learned response says this is what you do in an emergency situation. This is what you've been trained far more times than the new learning, and that's what becomes what we call the prepotent response.
Is there another phrase from your literature that it, quote, it's not the action, it's the outcome?
Yeah, you know, when something, you know, I'm explaining a very common psychological process that we've all gone through, we can all relate to. But almost in every case, fortunately, they don't lead to a tragic outcome. But what makes an action error, the critical ones, the ones we pay attention to, the aviation accidents, the surgical mishaps, or the law enforcement cases, is that there occurs a tipping point where the action that is taken, the prepotent action, happens to be one that can have a lethal outcome, whether it's pressing the wrong lever or moving the switch in the wrong direction on an airplane, whether it's using the wrong instrument or the wrong medication dose in a hospital, or drawing the wrong weapon in an officer-involved shooting circumstance.
Let's go then to what can contribute to action errors in police work. And one of the topics in your literature and your writing that is discussed is what's called an optimum arousal level. Are you familiar with that term?
Yes.
Tell us about that.
All right, so that's not a term that I invented. This goes back...
but you've referenced it in your books. Okay, go ahead.
You know, in order to do anything well, you have to be in a certain zone of arousal. In other words, you can't be too laid back and chill and uninterested because you're not going to have the motivation to do that skill well, whatever that skill happens to be. So you have to be a little bit pumped up, a little bit enthusiastic, a little bit motivated to do it. What happens is, as that arousal increases to the point where it starts becoming fear or agitation or panic, then you have the opposite effect. Then it begins to degrade your performance. Again, we've all experienced situations where we've been motivated to do something, but maybe the pressure is on, and we talk about sometimes choking under pressure or doing the wrong thing because we just got too hyped up. And so as long as we're in that range, and that range can be fairly wide, we do well. So typically what happens is when you have something like an action error occurring, it's occurring because that person has gone beyond, they have exceeded the optimum level of arousal for that particular task, so that higher levels of arousal no longer help, but now begin to hurt efficiency in performing that task.
Okay. And that includes such factors as hyperfocus, tunnel vision.
Well, hyperfocus, hyperarousal is what we mean by being outside that zone, and hyperfocus and distraction of attention are the main factors that being out of that zone tend to produce.
In your 25 years of experience with working with police psychology, have you studied critical incidences, shootings, that sort of thing?
Yes.
And you've worked with officers who've been involved in such incidents, have you not?
That's right.
And many of them involve deadly force.
Some of them, yes.
Okay. So what are the factors that would contribute to an action error in a law enforcement setting?
Well, any situation that involves an extreme degree of stress, which usually means a threat to life. We mean by a critical incident, we mean an incident where there is some credible threat to the safety or life of a police officer, of a citizen, of bystanders, and that requires an immediate response. Critical incidents don't only occur in law enforcement; they occur in medical, emergency room settings. They occur in firefighting and first responders. But here we're applying critical incidents to law enforcement, and in those cases, the factors usually involve an extremely compressed time frame. The person has to act very quickly, sometimes instantaneously. There is that high threat to life and safety. Often there are confusing and changing circumstances. The circumstances may be ambiguous. You're in a scene and you're not quite sure what's going on, and what's going on may change from second to second. And put all these things together, and this creates a high state of arousal and agitation, and that is exactly the kind of perfect storm for the production of an action error.
We've heard about the term weapon confusion. Are you familiar with that term?
Yes.
Okay. Is weapon confusion a form of an action error?
Well, weapon confusion is a subset of action error that applies to a specific law enforcement circumstance where...
Is there a particular term for it that you know?
Well, a term that's been used for it is something called a slip and capture error.
Explain what slip is and what capture is, then.
That term was coined by a police psychologist and refers to the fact that under these states that are conducive to action errors, these states of high arousal, hyperfocus, and impaired attention, the ability of System 1 to pick out the correct response slips away, and the actual performance, the actual behavior is captured by the older, more well-entrenched, more baked-in knowledge program that the person has been carrying around long before the newer, and in this case, what would have been the more appropriate program has a chance to engage.
Has that process happened in the literature in the arena of weapon confusion?
That's right.
Confusing, say, a taser for a gun.
That's the most typical example of what's meant by weapon confusion shooting.
Now, when you were talking about action errors before we got to slip and capture, you were talking about critical states and circumstances that would likely cause an action error in terms of police conduct. Is that correct?
Yes.
Okay. Or are there other factors that might well contribute to an action error when a police officer confronts an individual?
Well, we already know that action errors are more likely to occur under states of hyperarousal, hyperfocus, and distraction of attention. And we know that in critical incidents, you do have many of these factors occurring. Officers will typically report hyperfocus in the form of what's called tunnel vision. They're zeroed in on one aspect, usually the most dangerous aspect of a circumstance, and will tune out other goings-on and other things in the surrounding. They're under extreme time pressure. They're under circumstances that are confused and changing. And so, so what might be the types of circumstances that would produce that kind of high-wired psychological state in a police officer? And these are, police officers deal with citizens on a daily basis. In any given day, there are hundreds of thousands of police-citizen contacts, most of which are uneventful. The ones that do qualify as critical incidents usually involve situations where police officers have reason to believe there's a high danger level. And those are the ones that we're talking about.
How about whether or not the subject is intoxicated?
Well, things like a subject may be intoxicated, a subject may be mentally impaired, subject does not respond in the usual way that you'd expect a citizen to respond to a police officer, such as obeying a lawful command. If an attempt is made to arrest the suspect or the subject, the citizen may resist. Of course, if the citizen becomes violent or tries to flee the encounter or does anything that could potentially put the officers or other citizens in danger, and especially if you have a combination of these factors, that's more likely to produce these states of hyperfocus, tunnel vision, hyperarousal, distraction of attention, which in turn, if an action error is going to occur, that's the proper recipe for something like that to happen.
In traffic stops, in the police work that you've studied and experienced in your 25 years, are there certain risk factors that may also contribute to an action error?
And these are just a special example of the risk factors that we mentioned above. One of the most dangerous things about a traffic stop is you don't know who's in the car. It's the factor of the unknown. And so, people often wonder why, if there's a traffic stop, do you need so many police officers responding? Well, we all know.
Objection, Your Honor, this witness is not a police officer.
The objection is sustained for lack of foundation. You may lay additional foundation.
Sure. Have you studied in your 25 years the risk factors, for example, that may contribute to an action error in a traffic stop?
Yes.
I mean, you've done hundreds of interviews of police officers, which we can't talk about, obviously, but you have interviewed a lot of police officers who've been in these kind of things, in traffic stops. Is that correct?
Well, not all of the officers I've worked with have been in traffic stops specifically, but yes, a fair number of them have.
Yeah, you've seen hundreds of videotapes over the course of your career, and you've reviewed the literature of the stressors involved, have you not?
Yes.
Okay. So what are some of the risk stops, the factors that maybe come in play in a traffic stop?
Well, very similar to what we described above. The subject may not respond to lawful commands. You don't know the occupants of the vehicle. If in fact you discover that there may be outstanding warrants or the vehicle may have been stolen, or other factors that lead one to believe that this person may show resistance, in some case violence resistance. These are all factors that sort of build up cumulatively in the first responder's mind. The reason is because first responders know that there have been circumstances where this has led to the death or injury of police officers and other citizens. And so the radar is likely to be on high alert in these circumstances. And then what often happens is if you analyze many of these cases, you look at the videos, you interview the officers, what you see is a tipping point.
What do you mean by tipping point?
At some point, a subject resists a command, resists arrest, does something which, if only that thing hadn't been done, the situation may have ended with an arrest, or even with a, have a nice day. But for whatever reason, somebody went somewhere, a word was exchanged here, an elbow went there, and a tragic result occurred. And it's disconcerting when that happens, because when you go back and you look at this and you run the scenarios in retrospect, you realize how many different ways these things could have turned out.
Okay. So it's a combination of all the factors that you've talked about.
Well, that's exactly it. We're talking about cumulative factors. There's no one thing that causes an action error. You have a set of circumstances that creates a certain emotional climate and a sense of danger. Then you have actions that are done by the citizen, actions that are done by the police, and if those sort of align in a particular way, then you have what we call the unfortunately rare occurrence of an action error that causes a tragic outcome.
And one of the factors that you've studied in the aftermath of such an error has to do with the police officer's memory of it. Would that be fair?
Yes.
And what have you studied in that regard?
Many police officers are themselves surprised that they don't recall certain aspects of what went on in the scene itself. Sometimes when they're questioned by authorities, do you recall what happened? The officer will say, I don't recall, or I have a spotty memory. And that relates to what we talked about earlier, about the different stages of memory: input, consolidation, storage, and retrieval. Most of the time, and again, it's not just police officers. If anybody here has ever been involved in a very frightening experience and lived to tell about it, there may be some aspects of it, and you look back and you say, I don't know how I got out of that car, or I don't know how I evaded that truck that was about to hit me, but somehow, next thing I knew, I was on the side of the road and I was okay. And that's because it's not a matter of not retrieving the information. Remember, the information didn't get in the first place. You were focused on something else. The officer was focused on surviving that encounter, and not only surviving that encounter, but hopefully ensuring the survival of other people on the scene. So the reason you can't recall it, and that officer can't recall it, is he or she, it didn't get into his or her brain in the first place. And if it did, it didn't have time to be consolidated by this memory formatting process in order to be stored in a way that could later be recalled.
What's a flashbulb memory? Is that in connection with what you just described?
Again, the paradox is where some memories may be missing or distorted, other memories may be the officer may be acutely aware of them. And again, these are typically memories for those specific aspects that presented the danger. Sometimes this is called weapon focus effect. It doesn't happen just to police officers. Crime victims, well, when asked to identify an assailant, will say, I don't even know what the guy's face looked like. I wasn't looking at his face. I was looking at the knife or the gun or the weapon that they were pointed at me. So again, the point is, what we're describing in the case of police officers is simply a special application of cognitive processes that occur in all emergency situations. Except in all emergency situations, you're not dealing with first responders who are charged with a very special task of protecting life and safety.
So in sum, it would be fair to say that action errors do exist, have been studied in the literature, and a subsection of an action error is a slip and capture error. Fair enough?
That would be a fair statement, yes.
Okay. And that's what you've just described to us.
Yes, it is.
No further questions.
Counsel, you may cross.
Good morning, Dr. Miller.
Good morning.
Welcome to Minnesota.
Thank you.
I hope the weather is treating you okay thus far.
When I can move, yes.
So I want to talk a little bit about some of the questions you were asked on direct, a little bit about your experience. I know you've written a number of articles, you've gone through a lot of school, but you talked about one of the areas of expertise you've developed is as a police psychologist. Is that right?
Yes.
And police psychology as a specialty, that wasn't recognized by the American Psychological Association until 2013, right?
As it happens, it is. There is actually a special section of the American Psychological Association called Police and Public Safety Psychology. It's called the section. The APA, American Psychological Association, has I don't know how many different sections, but that is now one of them.
And that's a recent change, as of 2013.
I don't recall the date, but I'll accept that.
But in any case, the work that you do in terms of the way that you make your income, it's primarily on behalf of police and police entities, right?
I'm just going to ask you to speak up just a little bit, please.
You work primarily with police officers and police departments?
Well, that's one aspect of my practice. That's not my entire clinical practice.
But a lot of your consulting and the work that you do that generates income is for police departments and police officers, right?
Some of it, yes.
And are you still working closely with law enforcement in your local area?
Yes.
And that includes the West Palm Beach Police Department, the Palm Beach County Sheriff's Office. Is that right?
Those are the two main agencies that I work with on a regular basis.
But you've also worked with national police organizations, other types of police forum venues, if you will.
Well, I do consulting, expert witnessing, and a lot of training with many of these other agencies around the country.
And you're also affiliated with Police One, correct?
Police One, the website, yes. I have a web page on that.
And that website, that's a site for the law enforcement community, right?
For the law enforcement community and also other professionals who work with law enforcement.
So they have a lot of articles and resources for police officers on that site, right?
That's right.
And some law enforcement only content as well. Fair?
I'm sorry, some what content?
Some, if you're a member, you can log in and get some law enforcement only content, correct?
I think that's right, yes.
Okay. And you're identified on their website as a police columnist, as well as all of the other things you do, right?
Yes,
And you've written a number of articles for Police One over the years, correct?
that's right.
And many of them are listed in your pretty voluminous CV, right?
That's right.
And you spent, I think you told counsel, 25 years or so of your career working with law enforcement.
That's right.
And you also mentioned that you testify as part of your consulting work on behalf of police officers, right?
That's one of the things I do, yes.
And that's primarily who you testify for police officers, police departments.
What do you mean by for?
In terms of, well, you mentioned civil and maybe criminal litigation. Typically, when you're offering testimony or you're consulting, that's on behalf of the police officer or in a criminal case, the defendant, right?
In most of those cases, yes.
And I know you said it's not the only thing that you do, but that's a big income generator, right?
It's one of them, yes.
And for this case, you were paid, you said $30,000 for your work, is that right?
That's right.
And that you described involving today's testimony, but also an interview with the defendant, Ms. Potter, correct?
Yes.
And you said that there was also a review of records, right?
Yes.
That was part of your review. But you didn't review the whole file in this case, correct?
The entire file? No.
You, in your report, identified the materials you reviewed, correct?
Well, I reviewed somewhat more than those materials. Those in my report are the ones I felt were most relevant to me formulating my opinion.
Okay. And in your report, you identified, I think, 3 documents and 1 composite video clip. Is that right?
Yes.
You didn't review any training materials in this case, correct?
I did review some training materials, but I did not put those in my report.
Well, you didn't review any department policies.
I don't have the entire file with me, which is, a big stack, but I do recall reviewing training records, training materials, SOPs, other documents, transcripts of other witness statements, and a wide variety of things that didn't all work their way into my report. Otherwise, it would have been a 100-page report.
Well, in your report, you included just a few of those materials, right? Including the transcript of a statement by Officer Lucky, the summary of video recordings, the complaint, and I believe the composite video, correct?
Yes.
And then a lot of your report is dedicated to your commentary on your interview with the defendant, Ms. Potter. Is that right?
Yes.
Fair to say that the majority of the information that you got came directly from the defendant, Ms. Potter.
Well,
right?
yes, she was the focus of this case.
I'm going to talk a little bit about that interview with the defendant a little bit later, but let's get back to some of the work that you do more broadly. You talked about System 1 and System 2 processes as part of sort of those psychological components when it comes to how our brains work, right?
Well, that's the way I'm conceptualizing this case for the jury, yes.
And you talked about how things that are learned early on become sort of regular, sort of automatic type of behaviors, correct?
Yes.
And that would include things that we would learn, at childhood, for instance. Fair?
Well, I mean, some of these things go back to childhood, but we also do quite a bit amount of learning as adults.
Sure, we continue to learn as we grow older. Is that fair?
Yes.
But things like learning left from right, that's something that's done at an early age, right?
Yeah, yes, hopefully, yes.
Now, getting back to some of the training that you do, I think you talked a little bit about training. You provide some training to law enforcement officers as well, right?
Yes.
And that includes how to manage stress, ways to avoid using force, things like that.
That's essentially right, yeah.
And you've written, I think there was a book shown, you've written a number of papers and books even about the management of stress for law enforcement officers, right?
Yes.
You'd agree that managing stress is an important part of a law enforcement officer's job?
A law enforcement officer and anyone who finds himself in a high-stress circumstance during their job, yeah.
And you'd agree that it's a high-stress job being a police officer?
Yes, it is.
They encounter stressful situations often?
Even if it's not often, even if it's occasionally, the ones that they do encounter can be quite stressful and quite dangerous.
And so managing that stress is an important part of doing that job, correct?
That would be right.
Including things like determining when to use force, how much force to use, things like that.
Well, that's actually more of tactical training. In terms of the procedures used, that's more of a tactical issue than a stress-related issue.
Fair enough. So other people train on what force to use and when, but for your purposes as a psychologist, in terms of imparting that knowledge, it's important for you, in your profession, to impart on officers how to manage their stress, how to make decisions under stress, things like that.
That would be right.
And you mentioned a variety of articles, and I know that you said that you wrote for Police One as well. One of the articles that you wrote for Police One in 2010 was called Understanding an Officer's Reaction to That One Big Mistake. Do you recall that?
I do recall that title, yes.
And you called those OBMs for short. Is that right?
I'm sorry, what was that?
The abbreviation for that was OBM, One Big Mistake?
One big mistake, right.
You also referred to that as OBFU, correct?
That's right.
And that stands for what?
OBM stands for one big mistake.
And OBFU, which is but in that article, you use those abbreviations to refer to those terminologies, correct?
Well, I used the abbreviations, but the terms were used by the police officers themselves.
Okay. And so in that article, you acknowledge that OBMs, however you characterize them, are preventable, right?
Some of them are, yeah.
And in that article, you wrote, quote, "Yes, class, you've heard me say this 1,000 times before, but the fact is many OBM incidents occur in response to the deer in headlights freeze response that occurs when officers aren't sure what to do and have to wing it on the spot. And many of these mental choke points are preventable through the use of proper training and practice. This includes proficiency with firearms, non-lethals, vehicles, and communication equipment. It also means basic expertise in proper approach, citizen confrontation, vehicle stop, dwelling search, use of backup, suspect search, physical restraint, and arrest technique. Equally important is training in verbal communication and nonviolent conflict resolution skills so that potentially dangerous situations can be diffused before they require cuffs, volts, or bullets." Those were your words, right?
No police psychologist and no police officer is going to contest the fact that the more training, the better. But the whole concept that we're discussing today is despite training, and in fact relies on training, that certain types of training may become more prominent than others.
You answered the question. Those were your words, correct?
Well, I'll give that long paragraph a yes.
But you're acknowledging that, at least as early as this article 2010 and likely before, that this is an important part of the knowledge that you're imparting on these officers who are reading your articles, right?
Could you just repeat and rephrase that, please?
Prevention is half the battle, essentially, right? Is sort of the takeaway.
Prevention is always preferable than follow-up, yes.
And you mentioned that training can play a big role in that. So things like scenario-based training, trainings on managing stress and making decisions under stress can help prevent these types of things from happening, right?
Well, the whole concept of training is good is something that nobody's going to contest.
And you've been training officers on how to do these types of things, manage stress for decades, right?
Right, not the operational aspect, but the stress management.
With the stress management. Essentially, to help them have these situations turn out the best way possible. Fair?
Yeah, that's fair, yes.
And that's because you're aware that stress can affect how people behave, right?
Yes.
Can impatience also influence someone's behavior?
I'm sorry, what was that?
Impatience. Can that affect how someone will behave?
I'm not quite sure what you mean by impatience.
Well, if someone acts impatiently, that can influence how a situation will turn out. Fair?
By impatiently, do you mean impulsively? Because impatiently seems to imply sort of a lack of wanting to wait for something. And I'm not sure how that would apply to this type of circumstance.
Well, if a person acts impulsively or impatiently or acts too quickly, that can affect how a situation will turn out. Fair?
I can't say that's fair only because quickly is not synonymous with impatiently. People can act quickly and act adaptively, and in fact, most of the circumstances that we're talking about, that's exactly what happens.
All right, that's enough. That's an answer to my question. Thanks. So if you can't answer that clearly what you've talked about is stress management, right? Stress management is something important for officers, right?
Yes.
And part of the way that they're trained to manage stress is to suppress certain behaviors when it's necessary under stress, right?
Well, preparation for a particular task is one way of handling stress. The more competence
It's a yes or no question, sir.
Can we go back to the question?
Excuse me. Everybody has to follow the rules. Please don't interrupt him when he's in the middle of a sentence. Let him finish his answer before you ask the next question. Did you need the question repeated?
Yes, could you please repeat?
It's a yes or no question, sir. Are officers trained to control their stress?
They often are and should be, yes.
And when it comes to the brain and how the brain functions, you discussed about how our brains can be flexible, how we can change behaviors, right?
Yes.
I think you said something, I don't know if it was the frontal lobe, but some portion of our brain allows us to plan an action, but also to shift gears when appropriate, right?
Yes.
And I think you said that we save brain power for things that are more challenging, where we have to focus on unusual aspects. Fair?
Well, we save the thinking and reflecting part of our brain power for those purposes, yes.
And again, training and experience has a lot to do with how someone will respond to a stressful situation. Fair?
That's fair.
And someone who has been trained repeatedly is better able to control and manage stress and better able to adapt. Fair?
All things being equal, that is correct.
You were also asked about high-stress jobs, things not only like law enforcement, but also other fields. There are lots of high-stress jobs, correct?
I'm sorry, repeat that last one, please.
You mentioned aviation, things like medicine. There are other types of high-stress jobs, correct?
Yes.
But with fields like those and law enforcement where people have to deal with high stress, through your psychological experience and the training that you impart particularly on officers, is the training done so that officers can and that they are expected to be better prepared to respond appropriately in those situations?
Yes, I think I said that earlier.
Okay. You talked about the job of a police officer, right? And that sometimes there are other factors that might come into play with respect to an individual suspect's behavior. Fair?
I'm not sure what you mean by other factors.
Well, you mentioned sometimes people might be under the influence of drugs, right?
Well, those are factors that would heighten an officer's arousal level to danger, yes.
Sure. Sometimes people flee. Sometimes people can be violent. You mentioned those examples.
Yes, I did.
And those are all things that officers are trained to respond to, right?
That's right.
You also talked about the term slip and capture as a particular way that action error has been sort of adapted for law enforcement, right?
Yes.
But slip and capture isn't a term that's generally accepted in the field of psychology at large, is it?
Well, it's not a diagnosis, but it's simply a way of describing a cognitive phenomenon.
But that's a term, the slip and capture term, that you and others in the field of policing have coined, correct?
That we do what?
That's a term used in the field of police psychology, right?
Yes, it's used.
And used by individuals like Dr. Bill Lewinsky.
Yes.
And you relied on his prior work in formulating your opinions in this case?
I don't rely on anything that Dr. Lewinsky said in formulating my opinion on this case, other than simply the use of the term slip and capture.
Okay. And you're aware that his research has been characterized as junk science in other forums as well?
I don't know what you mean by characterized.
Well, the term slip and capture has no foundation in the general field of psychology at large, right?
The term may not, but the concept certainly does, and that's what we mean by an action error.
Okay. So we can talk about action errors. As applying the term action error in this case, you're relying on your knowledge of research into the area of stress and perception, and sort of the general psychological term of action error. Fair?
Well, no, it's not a general psychological term. If you looked at the bibliography that I appended to my report, you'll see there are numerous references in peer-reviewed journals of descriptions of action errors occurring in the different fields that you mentioned earlier.
Sure. So action error is a term that has been studied in psychology, but slip and capture, not so much. True?
The actual term, again, is something that was applied, so it would be a handy phrase that people in law enforcement could use who are not familiar with the literature on action errors, but the term is almost irrelevant because it's describing the same phenomenon.
But when it comes to law enforcement, there's really not much peer-reviewed research connecting the research on stress with a police officer's action in firing a weapon, right?
No, that's not correct. There's a whole literature on cognitive distortions and other types of errors that occur in officer-involved shootings, much of which I built my book around to sort of have a handy compendium for researchers and law enforcement personnel to describe. So everything we know about officer-involved shooting and the cognitive processes that occur in those emergency critical incidents does have a long research and clinical practice history.
So some of those phenomena that you described include, you said, cognitive distortions. Is that right?
Yes.
And you used a term, I think that was referred to as tunnel vision or visual hyperfocus, right?
Yes.
And that's what you described as where, under these stressful conditions, someone will zero in on the threat or the suspect and sort of tune everything else out, right?
That's essentially the concept, yes.
And you talked about weapon focus being part of that as well, where people will focus on the weapon and not the surrounding circumstances.
Weapon focus is an example of tunnel vision.
Basically, tunnel vision being a condition where they would focus on that threat and not register what's going on or what people are doing or saying around them.
That's essentially correct.
Okay, so getting back to this concept of action error and these other fields that you mentioned, medicine, aviation, things like that. You describe that action errors are a known phenomenon in life, right?
Well, they are very common, yes.
And because action errors can happen, there are a lot of policies and procedures and systems in place to prevent fatal consequences of an action error. right?
Well, the action errors that we strive to prevent are precisely those that can cause a danger, not just to ourselves, but to other people.
And in striving to prevent those types of action errors, you mentioned medicine, things, there are policies in place where, for example, there are checks on systems and how medicine is administered in hospitals, things like that, right?
Yes.
And in aviation, there are different knobs and different buttons that are different colors and in different places, multiple buttons to press so that there's sort of checks on the system. Fair?
Yes.
And your report talks about this phenomenon of action error, but it doesn't talk about error avoidance or error detection or error mitigation, right?
Yes, and there is a reason for that.
But those things are all also studied and known in the field of psychology and also human factors, right, in the way that these issues are addressed in the real world.
I'm not sure I understand the last question.
There are systems in place to address action errors in many professions, including medicine, aviation, and policing, right?
In those two professions, the first step is to identify them, to characterize them, and only then can we begin to develop ways of trying to mitigate them or to prevent them. And since the study of action errors in law enforcement is much more recent, we're still in the process of validating, cataloging, describing the types of action errors that occur. And of course, the hope is that just like these other professions, we'll get to a point where we can design mitigatory strategies for preventing these in the future, or at least minimizing them.
So there are things in place, systems in place, to minimize or prevent fatal consequences from action errors, right?
Not as well developed in law enforcement yet as occurs in these other fields you mentioned.
Okay. Well, there are things in place in law enforcement that you'd agree are similar to the things in place in other fields. For example, things like design. There are systems of design that can be implemented to address action error. Fair?
Could you be more specific, please?
So things can be designed to look different from one another. For instance, a taser can be bright yellow while a gun can be black, right?
That's correct.
And that design difference is one way to make noticeable the differences in those two devices. Fair?
That's the intention, yes.
And there are things like policies and procedures in place in terms of how officers are required to carry their weapons, for instance, to address this type of risk, right?
Yes.
For instance, like carrying your taser on the opposite side of your duty firearm, right? Using the opposite side of your duty belt.
Yes.
Things like having different holsters, different mechanisms for draw, right?
Again, I'm not testifying here as a tactical expert, but in a general sense, I would agree with that statement.
And you'd agree that practice handling those weapons can help to reduce those errors as well. Fair?
And the more practice, the better the effect.
And things like handling a weapon on a daily basis can help with that as well, right?
Right. Practice with any technique, the more it's practiced, the more it gets baked into the brain, the more likely it is to occur when you need it.
So I'm going to get to your interview with the defendant in this case. You indicated that you did conduct an interview.
Yes. Okay, the objection is sustained.
Dr. Miller, just a few more questions. You reviewed video in this case, correct?
I'm sorry?
You reviewed some video in this case?
Yes.
And you'd agree that the defendant's handgun was just inches below Officer Lucky's face when she fired?
Beyond the scope.
The objection is sustained.
Nothing further, Your Honor.
Is there redirect?
A couple of questions for you, Dr.
Sure.
Miller. Okay. Despite training in error avoidance and error detection in the industries that you've studied, action errors still happen.
Yes, we can't control every circumstance.
In medicine, for example, how many errors occur? How many deaths occur every year as a result of action errors?
Objection, lack of foundation.
If you know.
The objection is overruled. You may answer.
According to one source, over 1 million a year. These don't necessarily involve serious injury or death, but just errors that occur in which an adverse outcome does occur.
And this is a profession that is highly trained to know that they can happen, and they still do.
I mean, I'm not an expert on medical procedure, but that would be a logical assumption.
And they still occur where there's a great deal of training involved.
Yeah, I mean, the broader point is it's unrealistic to expect zero errors in any profession. Our goal as responsible professionals is to bring that number as low as possible.
But it still happens. Yes?
I'm sorry?
It still happens, though.
And so far they still happen. But again, that doesn't relieve us of the responsibility of still trying to reduce how often they happen.
Thank you.
Is there anything across?
Briefly, Your Honor. Dr. Miller, you testified that there are many action errors that occur in medicine, correct?
That's my knowledge, yes.
How many of them are fatal errors?
I have no statistics on that. I don't know.
How many planes fall out of the sky every day?
Fortunately, very few.
Nothing further.
Anything further?
I know you're...
Okay. Thank you, Doctor. You may step down.
Thank you, Your Honor.
All right, members of the jury, we're going to take our morning break, so 20 minutes. Okay, you may be seated. When we were conferring with the headsets on, we were talking about the fact that my prior ruling was that although there could be testimony about slip and capture, no person could, no expert is entitled to testify that that actually happened with respect to Officer Potter on April 11. So there's going to be a rebuttal expert as well on the slip and capture issue. If you open the door to that, either side, well, if the state opens the door to anything of that sort, getting into her testimony or her statements to the expert, I am going to allow recall of Dr. Miller to have him testify. So just so we're clear on that.
And just to be clear for the state, Your Honor, we are asking that Dr. Miller not be released from his subpoena so that he may be recalled in the event we do wish to recall him.
Counsel, that's a legitimate request.
I missed the last phrase.
That's a legitimate request. Okay. All right.
Available today, Your Honor.
Right. Okay. Thank you, counsel.
Well, good morning, everyone. Tim Blotz here in the Fox 9 newsroom. You've been watching our continuing streaming coverage on fox9.com and on our YouTube channel, and additionally on Fox 9 television, of the trial this morning of Kim Potter, all for the manslaughter charges she faces in the death of Daunte Wright from that traffic stop that happened back on April 11th of this year. She has pleaded not guilty in this trial and has promised all along that we would hear from her. At least her attorneys have told us that we would hear from her. It's the intention that she will testify yet today, perhaps even this morning after we come back from this break. First on the stand, though, this morning, the defense witness, Dr. Lawrence Miller, who has a PhD in psychology, testifying about this concept of what's called an action error. When you do one thing, when your brain tells you to do one thing, but you do something completely different because that's what your brain goes back to. I want to bring in Paul Bloom here and our legal analyst this morning, Debbie Lang, who's a criminal defense and trial attorney with Hallberg Criminal Defense. Paul, I want to start with you because some very important testimony here, at least from the perspective of the defense.
Yeah, this is their psychology expert trying to explain, although you noticed the doctor couldn't opine specifically about whether now former officer Kimberly Potter was suffering from this phenomenon of slip and capture action error. In essence, well-trained, the more dominant action during that traffic stop would be to unholster and pull her firearm in a fast-moving environment rather than reaching over and grabbing the taser and deploying that, which by all accounts she intended to do. Thought the prosecution certainly had a strong cross-examination. Debbie may disagree. I know she wears her criminal defense attorney hat, but got the kind of the term in there of junk science, this action error, slip and capture, sort of a phenomenon within policing. The doctor there, the prosecution brought out one that defense paid him $30,000 to consult, and that most of his work is done in support of law enforcement. And with that, we do have Debbie on our Zoom link. Thank you so much for joining us. Debbie, your takeaway, kind of interesting testimony in that he discusses the phenomenon of what occurs, you know, in the most basic of terms, when the new year switches and we flip the calendar and we're still writing the prior year date on it. Trying to sort of draw that out to the more serious situation of a life and death traffic stop. Your thought on his effectiveness and the defense use of him right there before the defendant gets up on the stand to tell her story.
I thought it was it will be a good use of that specific witness. Although he wasn't allowed to testify specifically about this case, he couldn't talk about Daunte Wright and Kim Potter. You heard him bringing in examples that are present in this case. So he wove those in as he talked about the stressors that an officer can feel at a traffic stop, not knowing who they're stopping, if there's a warrant, if the person resists. So you heard him planting those seeds. And now it's going to be up to Kim Potter to actually connect the dots and talk about the fact that she was concerned because of the warrant, because of his actions, et cetera, to really help loop that testimony in to the case at hand here today.
Here, Debbie, Tim here. I thought that on cross-examination that Aaron Eldridge for the state did a rather effective job here, though, at trying to get on the record that there are systems in place to prevent action errors, such as training, and the fact that the taser is yellow, the handgun is black, that the taser you actually wear on the reaction side of your body, that is your non-dominant side of your body, to prevent these kind of action errors. I'm not a legal expert like you are, but it seemed to me that that was important to get on the record here for the prosecution.
It was absolutely necessary for their theory and their case for them to do that. I thought that that Dr. Miller, was very honest in terms of saying that, yes, we aim to eliminate action error, but it still exists. So he certainly had to acknowledge the fact that there are policies and practices in place to try to minimize action error, but in no field has it been entirely eliminated. And again, that's because it's a process of the brain. And so he also was very clear that when looking at law enforcement and action error within the law enforcement community, it is more recently studied and has been more recently addressed than in other fields such as aviation and medicine. And even in those fields, action error still has not been completely eliminated.
She also tried to impeach him a little bit on the one article that he apparently had written, where he said that that the OBMs, the one big mistakes that law enforcement makes, are preventable by training. And he did not deny that, but again, he still acknowledges that despite all the training in the world, these errors can happen.
Exactly. And, he went back, and at the end of his at the end of Cross, he had talked about the fact that he finally put it in some layman terms when he said what is baked into the brain is more likely to occur when you need it. And so, initially when this expert began to testify, I had some concerns. That the verbiage he was using was not going to resonate with the jury. And so as a defense attorney, I was happy to see that as he continued, Mr. Eng led him to examples that would help the jury relate and really understand these principles and these concepts. And then as he continued with his testimony, we saw him using terms and explaining things in a way that you don't need a PhD in psychology to understand. And so that, I think, was a very good aspect of his testimony. And, in terms of the junk science comment, he certainly tried to avoid it as best he could by indicating that action error has not been classified that way. It is the slip and capture, which is a subcategory. And again, he focused on the fact that it hasn't been studied as long, slip and capture with the law enforcement community, as action error, which is, across all different professions and exists for everyone in their work life or even just their everyday actions.
In fact, I wrote down his exact quote here today when he was being cross-examined on slip and capture and that particular term, and he said, quote, "It was a handy phrase," end quote. And he goes on to elaborate and says, "But it's all irrelevant because it describes an action error." Getting back to his original definition of what causes these action errors, the system 1 and system 2 processing that goes on in the brain, and how when in the heat of the moment, or as he described here, I'm looking for it, when there is a hyper arousal, that when your brain is hyper aroused, the brain will default to what it knows.
Absolutely. And I'm interested to see as well Kim Potter's testimony, because he was speaking about how hyperfixation as well, and how someone will be hyper-focused on the threat. So here I am interested to see if Kim Potter's testimony is going to be that she was hyper-focused on Daunte Wright, or if she was hyper-focused on the threat to Sergeant Johnson and the possibility of him being injured if that car were to go in motion. So again, Dr. Miller gave these principles, and we're going to see how the defense chooses to apply them. But they're definitely going to hit those three factors that Dr. Miller talked about: hyper-arousal, the extreme degree of stress; hyper-focus, you zero in on the one thing that you are thinking of most or concerned most about; and then the distraction of attention, or the impaired attention. And so again, that may be everything else that's going on then captures her attention. So it will be interesting to see how Kim Potter's testimony is woven into Dr. Miller's principles.
Paul, I want to bring you back in here today because you've isolated some key moments of testimony here from Dr. Miller, haven't you?
I have, Tim, and I just think it's a fascinating discussion. I get you can label it as slip and capture, action error, a mistake was made. It certainly doesn't change the state's theory of this case, that in the biggest moment of Kim Potter's career, she failed it. And the state has said over and over again, she was trained, she was practiced, she had a bright yellow taser in her offside holster, a holster that's different than pulling out your gun. And in that moment, she should have been ready. Whether you call it a slip and capture, it was an error. And obviously now the case sort of has this new dynamic with the idea that it doesn't just have to be a mistake necessarily, but perhaps potentially that was a lethal force, justified incident. So in the end, again, how it plays out with Kim Potter's testimony coming up. But certainly let's listen back to Dr. Miller. This is a key moment here, talking about the junk science and whether the phenomenon of slip and capture and action error is accepted in the psychology field at large.
You also talked about the term slip and capture as a particular way that action error has been sort of adapted for law enforcement, right?
Yes.
But slip and capture isn't a term that's generally accepted in the field of psychology at large, is it?
Well, it's not a diagnosis, but it's simply a way of describing a cognitive phenomenon.
But that's a term, the slip and capture term, that you and others in the field of policing have coined, correct?
That we do what?
That's a term used in the field of police psychology, right?
Yes, it's used.
And used by individuals like Dr. Bill Lewinsky.
Yes.
And you relied on his prior work in formulating your opinions in this case?
I don't rely on anything that Dr. Lewinsky said in formulating my opinion on this case, other than simply the use of the term slip and capture.
Okay, and you're aware that his research has been characterized as junk science in other forums as well.
And that was Dr. Lawrence Miller just a few minutes ago. Obviously, now in this 20-minute court recess, we believe when we return, this jury steps back into the courtroom, Judge Chu will ask the defense if they have another witness to call, and they will say the name Kimberly Potter, and Kimberly Potter will head up onto that witness stand. With that in mind, Debbie, again, we don't know with 100% certainty, but our understanding of defense case now is their last witness is the defendant herself. What is happening in these final few minutes, this last break, before basically she goes up and puts her fate on the line in front of this jury and tells her story? What are these final minutes like between her, counsel, and perhaps some family members in that room?
I would suspect that right now that she is receiving support. I doubt that they're sitting down right now banging through questions or discussing Dr. Miller's testimony at length. Right now, I think they're telling her that she needs to stay calm. She needs to tell what she remembers, be honest, be truthful, and that the truth is what's important here for her. And so I think right now they're probably just holding some hands likely and breathing.
Tim Blotz here. I have to believe that her attorneys, Earl Gray and Paul Lang, have well prepared her for this moment.
Absolutely. So she has been prepared likely well before the trial date was set. And so she has gone through questions. She has been scrutinized by the defense team. They have put on their hats and pretended that they were cross-examining her. They have done the direct examination time and time again. And so she has been prepared. She anticipates what's to come. And that's why right now it's not about those questions and about the exact words she's going to say. It's about her demeanor and making sure that she is in a place where she's able to stay calm and remember those things that she had practiced and that she discussed, and then be able to relate to the jury and tell them in an honest way.
Debbie, and I think it's important to remind our viewers here, let's take a step back here and remind everyone that she has the constitutional right not to testify. And before she takes the stand, Judge Chu is probably going to remind her of her constitutional rights not to testify. In fact, there's been two moments in this trial so far, and once was during jury selection and at another time this week, where the judge did ask her, "Are you willing to testify?" And she said, "Yes, Your Honor, I am." But I have to believe, just to make sure that she is abiding by the defendant's constitutional rights, that she may ask that a third time today, correct?
I would not be surprised. There are only a few things in a trial and in a criminal case that the defendant actually decides, and whether or not to testify is one of those decisions. Her attorneys can give her advice on that, but ultimately it is 100% Kim Potter's decision. And in addition, not only does she have the right to remain silent and not to testify, but what attaches to that as well is the inability for the state or anyone else to negatively comment on her failure to testify. So she understands and she knows if she does not take the stand, no one can say she must be guilty because she wouldn't testify. They cannot comment. And so the judge is going to make certain, again, I would suspect, that in fact she understands she absolutely has that right, and that she is giving it up knowingly, voluntarily, and after consulting with her attorneys.
And Debbie, Paul Bloom back joining the conversation. I know we have some new viewers because we are on Fox 9 this morning. So I really want to bring it all the way back as Kim Potter gets prepared or prepares herself to step up onto the witness stand to really talk about the charges here. We kind of quickly gloss over them as we've just reporting on the day in and day out. But important to note sort of the definitions here and what we're talking about as we listen to Potter's account of what happened that day. And that is manslaughter in the first degree, involving recklessness of a firearm, the way she would have used it, picking out the wrong weapon at the time, and then shooting Daunte Wright one time. And as the prosecution has explained, the one bullet tearing through Daunte Wright's chest and basically blowing up his heart. And we do have the definitions of man one, man two to put up on your screen, and then the recklessness of man one, and then two, culpable negligence. Again, causing the death of Daunte Wright by creating unreasonable risk while using her firearm that day. Explain the definitions. I know in the end, the jury instructions will be awfully critical when the jury has to parse all of this, but describe what the state is trying to prove in those two counts, manslaughter 1 and manslaughter 2.
So, Paul, you're absolutely right. This is going to be, I would suspect, the longest discussion that the jury will have in their deliberations. It's going to be discussing and trying to understand and define the terms recklessness as well as culpable negligence. The judge is going to be giving them jury instructions, and so we will all hear the final instructions that the judge decides on. But essentially, the reckless actor is aware of the risk and disregards it, whereas the negligent actor is not aware of the risk but should have been aware of the risk. And so that's where the state is going to be focusing again on her training. So if she testifies that she was unaware of her actions, we know she will say they were unintentional, but the state is going to focus on why, in fact, she should have been aware the differences with the taser and the gun, and they will focus on the fact that she should have been aware when looking at her extensive training as well as the policies and procedures within the department. And so that's the primary difference here, is the awareness of the risk and whether she should have in fact been aware, and then the disregard of the risk under both elements.
But another wrinkle in all of this, Debbie, to remind our audience, is the testimony of Sergeant Michael Johnson, who testified that he was in the car trying to put the car into park and was backing out of the car as all of this happened. And because of that, that's created another scenario for the defense that she would have been justified to fire her gun to protect the safety of the other officers involved. And because of that, Judge Chu last night said that she would allow an additional jury instruction of authorized use of force. So the jury will have that to consider now too, correct?
Absolutely. And I would expect that the state is going to focus the jury on Kim Potter's reactions after she fired. So if she takes the stand and says, I could have used deadly force in that situation, the state is going to cross-examine her vigorously on her statements after. The fact that she had said, oh my God, I'm going to prison, I made a mistake. She used more colorful terms, of course, but they are going to be focusing on her immediate reaction. And during that time, we saw in the video, Sergeant Johnson lean down and put his hand on her back and say to her, I could have been killed. So the question's going to be, what did Kim Potter know at the time that she fired? Afterwards, Sergeant Johnson brought that to her attention, but she didn't make any comments about it. So that is going to be a point that the state is going to focus on and cross-examine her hard about, because that is key to them trying to combat the defense's argument that the use of force here, be it a taser or the gun, was appropriate. So that's going to be key.
All right.
Oh, sorry, Tim, I was just going to point out, coming off of Debbie's answer there, about there seem to be two key moments as we kind of have looked back at that body camera. It's been slowed down for various witnesses, but the idea was Daunte Wright in control of his vehicle as he gets back in. Was he ready to operate it? Was that about to be turned into a weapon, if you will? And then exactly where Sergeant Johnson's position is in or out of the car, and what does Kim Potter see from her side, and in that it all unfolds so quickly. With that, I'll have to cut myself off. Judge Chu taking the bench for what could be the make or break moment of this trial right here, right now.
Subpoena Dr. Miller. We'd like to have him stay at his hotel, which is at the Hyatt downtown. We have rides coordinated so we can bring him back here. But I don't see any point in having him sit in a room for all day either, but I'll honor the subpoena, of course, but we'd like him to stay at his hotel instead.
How quickly can he get here?
Well, about 15 minutes.
Okay. That should be fine.
And if there is a rebuttal witness, we've not heard about it. The state has not indicated any witness to be called today. And I know that the court referenced the rebuttal witness.
Yeah.
We'd like notice.
All right. Is the state intending to call the rebuttal witness expert?
Your Honor, the state's rebuttal is entirely dependent on the testimony of the defendant at this point.
Okay, so you haven't decided yet. All right. I just want to make it clear that if Officer Potter testifies inconsistently with what she said to Dr. Miller, I think it's fair game for the state to call Dr. Miller to testify. Okay? That is not going to open the door to the defense asking the ultimate question. I just want to make that crystal clear, okay?
So I know, Your Honor, if they ask questions on that report, did you say this? Did you say that? And now the jury knows that she was interviewed by Dr. Miller, and they're going to wonder what the diagnosis was. We never mentioned that she was interviewed by Dr. Miller, That opens the door, doesn't it?
No, because, Mr. Gray, that would just be pure impeachment of her factual testimony.
Okay, what happens if she says, no, I didn't say that? It was on a Zoom meeting, and it wasn't recorded, and she says, I didn't say that. And then they recall Miller. Does that open the door?
No, because it would just be pure impeachment of
Well, now we have
her factual testimony.
Well, now we have a situation where he interviewed her, he wrote a report, and they're going into that, and we can't show the result of his interview and his report, even though they're going into it. That's not fair to the defendant, Your Honor. Totally not fair.
Well, Mr. Gray, that's my ruling.
Okay, I just wanted to make sure I didn't make any mistakes up there.
Okay.
I don't want to do that.
All right. Okay. Let's get the jury.
Your Honor,
okay?
before we do that, if it is the defense's intention to call the defendant at this point, I think we have to make a proper record before that happens.
We already did.
I think I already asked Officer Potter whether or not she still wanted to testify.
I would just confirm that as of today, I would just make an additional record, Your Honor.
Well, is your decision the same?
Yes.
Okay. Thank you. Oh.
Just that. That'd be fine. Thank you.
Okay, just that. Okay. All right, please be seated. The state may call its next witness,
Yes, Your Honor.
or, excuse me, the defense.
Yes, Your Honor. Defense calls Kim Potter to the stand.
Okay, Miss Potter? Please raise your right hand. Do you swear under penalty of perjury that you will truthfully answer questions?
I do.
This case.
I do, Your Honor.
Please have a seat, and please remove your mask. And Ms. Potter, I gave the rules for testifying, and you've been in the courtroom. Do you need for me to repeat them?
No, Your Honor.
Okay. State your full name and spell it.
Kimberly, Kimberlyann, Potter, Potter.
All right, counsel.
Thank you, Your Honor. Ms. Potter, will you speak into the mic? Because both of your lawyers have a hard time hearing.
Yes, there's just Kleenex here.
Okay. You stated your full name. How old are you, ma'am?
49.
And are you married?
Yes.
And is your husband in the courtroom?
Yes, he is.
And what's his name?
Jeff Potter.
And how long have you been married?
Over 25 years.
And when did you first meet your husband?
When I was 15.
And you're in high school?
Yes.
And did you reunite much later?
Yes, when I was in college.
And what does your husband do?
He works for a healthcare system now.
Is he a retired police officer also?
Yes, he is.
And where was he a police officer?
Fridley, Minnesota.
Was he also a member of a drug task force?
Yes, he was.
And with respect to your children, do you have children?
Yes.
And what are they, 2 boys?
I have 2 boys,
And what are their names?
Nicholas and Samuel.
And are they in the courtroom?
No, they're not.
And where is Nicholas?
He's an active duty Marine.
And where's that at?
He's currently stationed in Florida.
And your other son, where's he at?
He's in college in North Dakota.
And are they going to be home for the holidays?
Yes, they will.
Is your mother in the courtroom?
Yes.
And your sister?
No, she's not.
But is your brother in the courtroom?
Yes, he is.
And besides your brother and your mother, your father is deceased?
Yes.
And do you have any other siblings?
I have another sister and a brother.
And what are they? Do you know what their ages are?
My sister, my oldest sister's in her 50s, and my other brother's in his 50s also.
And what do they do for a living?
My sister works for a medical device company. My oldest brother works for a parking company, and my other brother works for retail.
Going back to when you were a youngster, where did you go to elementary school?
Immaculate Conception Catholic School,
And where was that located or is located?
Columbia Heights, Minnesota.
And did you live in that neighborhood?
Yes, I did.
While you were at elementary school, while you were going to that school, did you have a police officer visit your school?
Yes.
And do you actually know his name today?
Yes, it's Officer Michael McGee,
And where was he a police officer
the
at?
Columbia Heights Police Department.
And why was he at your school?
He was doing bicycle safety for grade school kids.
And you remembered his name. Anything else that was significant about him that caused you to do something in your life?
He was, on that occasion, he really influenced me as a youngster that the police are good people, and I wanted to be something like that someday.
And because of that, and because of him being at your school, did you start out doing that?
Yes.
And what was your first job or volunteer work as some type of a law enforcement officer, student, explorer, school cop?
Well, the first thing I did was when junior high was a school patrol officer, if that counts.
Yes, that does count. And what did a school patrol officer do back then?
It was junior high, so we helped the younger grade school age children get across the street.
And did you continue to do that throughout junior high?
Yes, 6th, 7th, and 8th grade.
And after getting into high school, what did you do?
The Fridley Police Department came to my high school and had a booth set up for the Fridley Police Explorers.
And did you join the Explorers?
Yes, I did.
Why did you join the Explorers? First of all, what is an Explorer?
It's part of the Boy Scouts of America. It's a area where you can have career enhancement, or you can learn about different jobs like law enforcement or firefighting, things of that nature.
And were you an explorer throughout your high school days?
Yes, I was.
I can't remember if I asked you what high school you went to.
Totino Grace High School in Fridley.
With respect to criminal justice or law enforcement, while you were in high school, besides being an explorer, did you do anything else?
I had jobs.
Okay, what was your job?
My first job was at a gas station.
What did you do there?
Clerk, cashier.
And did you continue that job throughout high school?
Yes, and into college.
Okay, so your next visit was college.
Yes.
Where did you go to college?
St. Mary's College in Winona, Minnesota.
And that's about, what, 70 miles from here, 80?
Yeah, it's down towards La Crosse.
Okay, it's in Winona.
Yes.
And what was your major at St. Mary's?
Criminal justice and sociology with an emphasis on elderly studies or geriatric sociology.
Why did you take those courses?
I wanted to go into law enforcement, and I had an interest in serving the older community and understanding their needs and wants.
Did you graduate from St. Mary's?
Yes, I did.
And was that a 3-year program, 4
It was a
years?
4-year program. I finished it in 3.5 because I had an internship in the summer.
And where did you internship?
The Columbia Heights Police Department.
Columbia Heights Police Department?
Yes.
Okay. And what did you do at the Columbia Heights Police Department?
I was assigned to an officer who was in their community-oriented policing program.
Did you also continue your Explorer career while in college?
I stopped being an explorer after my freshman year, and then I role-played at the annual conference.
What does that mean?
Every year, the Explorer program had an annual conference at Breezy Point Resort, and they needed role players, and they liked to use students or people that were in law enforcement.
So, you graduated from St. Mary's,
Yes.
and what did you do after that?
After that, I would have gone to Skills in the summer of 1994.
Okay, and what do you mean by that?
I went to Skills.
What does that mean?
I went to the police certification program so I could get hired.
And where was that at?
Alexandria Technical College?
In Alexandria, Minnesota?
Correct.
So everybody knows about 120 miles, 30 from
Yes.
here? And did you stay there while you were being educated?
Yes.
What kind of a program was that? How long was it?
It was 10 or 12 weeks.
And what do you mean, is that where you obtain your skills to apply as a police officer?
Yes, it was a hands-on training. I had the college education, the book knowledge, and then I went there for my skills program or my hands-on part from getting my license.
After this program, did you go out and try and get a job in law enforcement?
Yes, I did.
And were you successful at first?
Yes.
Well, did you have a job at Anoka?
Yeah, I worked at the Anoka Metro Regional Treatment Center because I graduated in January, in December. I couldn't go to Skills until the next summer, so I got a job.
All right, but you worked Skills, you were in Alexandria, correct?
Yes.
And the job you got was at Anoka State Hospital?
Yes.
That was between your Skills. Say that again.
So
slowly.
I got hired there in February, and I worked for a year on a calendar year. But the Anoka City Police Department would allow their students or their employees, to go to Skills and still have a job on weekends or when they would get back before they got hired as a law enforcement officer.
So at Anoka State Hospital, what did you do?
I was a security officer.
And Anoka State Hospital is basically a detox center now, is that right?
No, it had a detox. It had a countywide detox and a detox program. It also had drug and alcohol abuse rehabilitation and mental illness.
And what did you do there? You were in security?
Yes.
Does that mean you had to deal with the folks that are staying there, the residents?
Yes.
And were you successful in that?
Yes.
After working there, where did you go next?
I left there and got hired at the City of Brooklyn Center.
In what year were you hired at the Brooklyn Center Police Department?
1995.
And when were you sworn in?
February the 27th.
Of 1995?
Correct.
Who was that you're swearing?
My mother and my father.
So after you're sworn in, you started working as a Brooklyn Center police officer?
Yes.
And what year was that again?
1995.
So that would be, my math, 26 years before you resigned? Is
Yes.
that a fair statement?
Yes.
When you worked as a police officer at Brooklyn Center throughout those 26 years, did you remain a patrol officer all during that time?
I did.
And why was that? Why didn't you attempt to go up the ladder like the other officers we've heard from?
I liked my work. I enjoyed working with the community. I didn't want to be in an administrative role.
But did you also, even though you were a patrol officer, you did take part in other programs, for example, the FTO program, right?
Yes, I did.
And that's the field training?
Yes, I was a field training officer for many years.
How many years?
I don't have an exact number, 10 to 15.
And we've learned in this case what a field training officer does, but very briefly, what did you do?
I would get probationers in different stages of their training, either in their first phase, their second phase, their third phase, or their final phase. Usually, the primary phase or the first phase and the final phase were always with the same FTO. And then other FTOs would train the other two stages.
And why did you continue to do that for so many years?
I felt that I had knowledge and mentorship that I could help young officers develop into somebody I would want to work with and my partners would want to work with.
There are other programs that you volunteered for or joined while
Yes.
you were a police officer, is that correct?
Yes.
And after you became a police officer, what was the first program that you joined or volunteered?
I became an Explorer advisor for our Explorer post.
And what's an Explorer post? Is that the younger people that are...
Yes, the program through the Boy Scouts of America.
And in that program, you teach them about policing, is that right?
Yes.
And after that Explorer program that you joined, what else did you do as a police officer?
I was on the domestic abuse response team. I was also a crisis negotiator.
Let's stop at the domestic abuse program. How long were you on that? Approximately.
10, 12 years, maybe more, maybe less.
And what did that program entail?
We would respond, so officers would go out on domestic abuse situations or domestic calls, and if there was a victim of a crime or an arrest made, or not an arrest made, we would follow up the next day with the victims to see that they were getting the things they needed, like domestic advocates, walking them through getting order for protections if they had questions, and then helping them and checking in with them through the court process.
And did you enjoy doing that?
Yes.
Why?
Sometimes there were great successes, and sometimes there were very sad failures.
There's another program that you're involved in, was a hostage program?
I was a crisis negotiator for the parent umbrella of the EOU team, the Emergency Operations Unit.
And what did you do in that?
I was a crisis negotiator.
What does that mean?
We would go out on barricaded subjects, or we would go out with the, I guess a SWAT team would be the easiest way to describe it, on warrants. We would respond to calls where there may be people in danger.
And was your job to try and negotiate with the subject and get him to submit to being arrested?
Yes, he or she.
Was that your main job?
No, I was always a patrol officer.
No, I mean, as far as a hostage negotiator, that's what you did.
Yes, I was a crisis negotiator.
And what other programs were you in?
I was on the Law Enforcement Memorial Association Honor Guard.
And what is that?
So the parent is the Minnesota Law Enforcement Memorial Association. They do a lot of work to help survivors and their families make their way through the process of getting benefits after their officer is killed in the line of duty. I was on the Honor Guard.
What did you do being on the Honor Guard?
When I started in 1998, I was on the colors team for approximately a year or two, and then I went to the casket team.
Well, what's the color team?
The color team carries flags.
And the casket team?
We would carry the casket or the urn of the fallen officer and then fold their flag.
And would you be in contact also with the victim or the deceased family?
Sometimes with the family, a lot of times with the chief of police, because I would have to have to give the folded flag to the police chief.
And this was throughout the state of Minnesota?
Yes.
And these were police officers killed in the line of duty?
Yes.
Or other law enforcement officers?
Most of 99% of it would be killed in the line of duty, or we would do some retiree funerals.
Any other programs you're involved in?
I did a lot of crime prevention work for our police department and other presentations.
crime prevention presentations?
Yes.
What were those?
I was assigned an apartment complex in the city, and I would meet with management, and we would do some programming for their residents as far as personal safety, locking your car doors, taking valuables out of your cars, just regular safety in an apartment complex. And then I would do some other presentations on robbery prevention for banks in the city.
By the way, when you were doing the carrying caskets for that in that program, were you aware of officers that were killed in the line of duty by making a traffic stop?
Yes, Sean Patrick from Mendota Heights.
Objection, Your Honor. Move to strike and echo.
The objection is overruled. I'll let the answer stand.
During your 26 years as a police officer, did you ever receive any complaints for abusing your power?
No.
Did you ever receive any complaints from the public?
No.
In training, did you attend all the training sessions required by the Brooklyn Center Police Department while you were there?
Yes.
And with respect to gun training, laser training, you attended all those too, right?
Yes, I did.
And did you pay attention?
Yes, I did.
With respect to that, in your approximation, and I'm not asking for exact numbers, but with respect to the training, what would you say the amount of training was for the firearm, for the gun, and the amount of training for the laser? What would be the percentages there?
For the firearms, it would be probably 80%. We spent a lot more time on firearms than we did on taser.
And tasers didn't come into the being until years after you're a law enforcement officer, right?
Yes, I believe trainers in this courtroom had said 2002 or 2003.
And you started as a law enforcement officer, what year?
1995.
With respect to tasers, I say lasers, respect to tasers, there's been evidence in the case that you had a Taser 7, is that correct?
Yes.
And the evidence in that was that the Taser 7 was shaped like a gun, fair statement?
Yes.
And the Taser 7 had a dark black, or at least a dark handle, and a dark top. Do you remember that?
Objection. Leaving.
I'm trying.
The objection is overruled. You may answer.
Yes.
The Taser that you received, was it approximately a month before April 11th that you received this Taser? Do you remember?
In the courtroom, I was told I received it on March the 26th.
Okay. And also, while we're there, with respect to these tasers and testing them, the rule that we read said should test the electronics every day. Is that right?
Yes.
And there is testimony that you didn't test yours a couple days. Is that right?
Yes, that's what I was told.
And do you agree with that you didn't test it?
I don't recall if I would have or wouldn't have.
And was that an important feature for law enforcement officers with new tasers
No.
that never used them since they had them?
Correct.
And while we're there, did you ever use a taser, use it by actually shooting it in all of your years' career as a law enforcement officer?
I would take my taser out on rare occasions, but I don't believe I ever deployed it.
Okay, when you take your taser out, it's to de-escalate what is going on. Is that a fair statement?
Sometimes, or to prepare for what might be behind a door. Sometimes an officer has a gun and sometimes an officer has a taser out.
All right. And now the taser that was switched from you, did that go to one of your partners, that taser?
My old taser?
Yes.
I believe they were just put in storage at the police department.
And those tasers were all yellow, right? The
Yeah.
handle, the top, the whole thing was yellow.
Yes, except for the battery pack. I believe that was black, and there was some
Okay.
markings on the side.
I'm going to show you these tasers. Show you this taser.
Objection. May we have a sidebar, please?
Yes. All right, the objection is sustained.
Okay, well, do you specifically remember your old taser? By that I mean the one before the 7 being all yellow.
Yes.
And was that an X26 taser?
I believe it was an X26P.
P? So, with respect to the tasers, there's been evidence about signing some forms on warnings. Do you remember signing those forms?
In our annual training, we would be handed a form to sign, and I would sign it.
And do you remember the warnings on them at all?
Not from those days, no.
And with respect to weapons confusion, was there ever any training, actual training about weapons confusion as you remember it?
No.
Did you even know what weapons confusion was before?
Yeah.
Wait till I finish the question. Before April 11th?
It would be mentioned in training, but it wasn't something we physically trained on.
And by that you mean what?
There was no training on weapons confusion. You wouldn't be set in a dark room and told to grab which weapon.
So I'm going to go now to April 11th, 2021, a Sunday. And you surely remember that day. Is that correct?
Yes.
And you were an FTO that day for Officer Lucky?
Yes, I was.
And that day, what time did you go on duty?
6 a.m.
And was Lucky on duty at that time too?
Yes.
And about, what did you do during the morning? If you remember, did you just do drive around police work?
We just did police work. We would have checked a squad car if we wouldn't have had calls right away.
As a Sunday?
It was a Sunday.
So approximately around 2 o'clock, did you pull up in back of, or not you, Officer Lucky was driving the car, right, the squad?
Yes.
And you were the FTO. Where were you seated in the car?
In the passenger seat.
And tell the jury what you remember about first seeing the white Buick on that day, approximately 2 p.m. And talk slowly.
Officer Lucky and I were driving south on Zane Avenue North. We were talking about pursuit policies, doing some regular FTO training, and he observed a vehicle in the turn lane with a blinker on inappropriately.
And was that the white Buick?
Yes.
And did you have a conversation with him about that?
Yes.
And what was that conversation?
We discussed a little bit of suspicious activity. He noticed a pine tree or air freshener hanging from the rearview mirror, and the tabs were expired.
And did you stop that vehicle?
Officer Lucky wanted to stop the vehicle, yes.
And let me ask you sort of a hypothetical. If you had been working alone that day on Sunday afternoon at 2 o'clock, would you have stopped the vehicle for...
Objection, relevance, calls for speculation.
I can't even finish the question, Your Honor.
All right.
That's not fair. It's simply, they know how to try a lawsuit, I would think.
The objection is overruled. You may answer.
My question was, if you weren't with a field training officer that day and you were on patrol alone, would you have stopped that vehicle?
Most likely not.
And why not?
An air freshener to me is not, it's just an equipment violation. And during the COVID times, the high COVID times, the Department of Motor Vehicles was so offline that people weren't getting tabs, and we were advised not to try to enforce a lot of those things because the tabs were just not in circulation.
Okay, but you did stop the vehicle, right?
Yes, part of field training is that my probationer would make numerous contacts with the public throughout the day.
And what happened after the stop? If you remember, go ahead.
Before Officer Lucky stopped the car, he ran the vehicle, confirmed that the registration was expired and that the registered owner had a petty misdemeanor type warrant for some type of drug offense.
And that was the registered owner of the vehicle?
Yes.
So after you did that while you were still in the squad car and not...
Yes, it's part of the multitasking that a probationer will have to do, is run a vehicle license plate, call into dispatch, and initiate their lights.
Okay, and try and talk a little slower. I know you're probably nervous, but I'd like to get all this in. All right?
Yes, sir.
Okay, so you stopped the vehicle, is that right?
Officer Lucky initiates the traffic stop.
And what happened after he did that?
The vehicle stopped kind of in an entrance to the church on 63rd, and he got on the PA and told the vehicle to pull ahead just a short distance.
Was that because he was parked in the driveway of the...
Yeah, and I think there was a vehicle trying to come out, as I recall.
Okay. What happened next?
Officer Lucky and I exited our marked squad car. Officer Lucky walked up to the driver's door, and I stood at the right rear corner of the white Buick.
So you did get out of the car?
Most definitely.
And why did you stand where you were standing?
Part of it was so I could see where Officer Lucky was, and to provide cover to see what else was in the vehicle.
In your experience of 26 years and being a patrol officer all those years, is stopping any vehicle at any time that you don't know, does that be considered a dangerous situation?
Yes.
Why?
Sometimes there's guns in the car, sometimes there's uncooperative people. You don't know who you're stopping.
Yeah, because you don't know, right?
Right.
So while you were standing there in the rear of the vehicle, did you hear what Officer Lucky said?
I could hear parts of the conversation. He didn't seem to be in any distress when he was asking questions. He took out his notepad, and it looked like he was writing down something which would end up being a name and a date of birth.
Okay, and after he did that, did you two go back to the squad car?
Yes.
And at some point in time during the stop or right after it, Did Officer Lucky do anything in connection with obtaining another squad car?
Yes, he called for a second car to come.
What is that about? What?
It would just be a backup officer. The registered owner had a warrant of some nature. It wasn't a bad warrant. It was just a regular petty warrant, which would still, you'd want a second officer. Or I guess in this case, a third officer. Officer Lucky and I are considered only one officer.
And why are you and Lucky just one officer?
Because he's in field training and he's a probationary employee.
All right. So did the third officer, Officer Johnson, arrive at some point in time?
Yes, Sergeant Johnson arrived.
And was that before you looked up in the computer about this driver of the vehicle, or after?
I don't know exactly when he arrived. I know Officer Lucky and I were Officer Lucky and I were discussing running the name he was given through some various systems.
Okay, and did you do that, you and Officer Lucky?
Yes.
Was there any correction that you told him about during this time that he shouldn't have put the name in one?
He had gone to the Minnesota, because the driver didn't provide him with any government-issued ID, he would have to verify some information to run him properly in our system through TriTech. So you run them sometimes through Minnesota DVS with just a name and a date of birth. It'll give you a Soundex hit on various people with that either same name or common name with a date of birth.
So did you correct him on that?
We were talking about, I don't know if I corrected him on it, but
So what happened after that?
he would copy the OLN, which is a driver's license number, off the screen and then put it into our TriTech system, or CAD, and that would run him through the state for driver's license and warrants and other hits.
And did you find anything about the driver?
The driver came back with a suspended driver's license, gross misdemeanor, bench warrant for weapons, and protection order.
So a gross misdemeanor for weapons ordinance, what went through your mind, if anything, when you read that?
It would be concerning that there'd be a weapon on the person or in the vehicle.
And why would that be?
In my experience over 26 years, I have found guns in cars, either by accident or by them just sitting out in plain view.
And what about a person with a weapons warrant?
They're more likely to be carrying a weapon or have a weapon access to them.
So what about the was it a temporary restraining order that came up? Was that it? Or?
Yeah, I think they're called ex parte orders. It would be a temporary protection order until the parties would either have a court hearing in front of a judge to make it a permanent order.
And there would be a name of a female on that?
Yes,
order?
there was.
And was there a female in the Buick or in the automobile that was stopped?
Yeah, in the front. Yes, in the front passenger seat.
So after you learned that, did you also learn something? Did Officer Lucky tell you something about drugs or marijuana?
When he initially got back to the car, he told me there was a obvious smell of marijuana and some seedlings or shake residue on the center console and inside the vehicle.
Okay. So with all of that information, what did you do next?
We told Officer Lucky explained to Sergeant Johnson what was going on. I corrected.
Where was Sergeant Johnson? Was he in your squad car?
He was standing at my passenger door.
Go ahead.
And Officer Lucky was explaining to Sergeant Johnson what was happening and what he wanted to do. Officer Lucky only told Sergeant Johnson that he had a warrant, and I told Officer Lucky that he needed to tell Sergeant Johnson what the warrant was for. A weapons violation warrant would be cause for care and concern.
All right. And after that conversation, what happened, if anything, next?
We got out of the vehicle. Sergeant Johnson was going to the passenger side. And
Excuse me, don't mean to interrupt you. Back up a little, I'm getting ahead of me. What was the plan when you got out of your vehicle with Lucky and Johnson was outside? What was your plan?
The plan was for Officer Lucky to get the driver into custody for the warrant, and we'd further investigate with the female who she was and if she was the petitioner or the subject of the restraining order.
Were you required by policy and law in learning about that warrant to arrest the driver of that car?
Yes, it was an order of the court.
And with respect to the restraining order, or whatever you called it, did proper police procedure that you knew of for 26 years required to find out who that lady was?
Yes.
And why would that be?
It's my duty to find out who she is to make sure she's not in harm's way. There's been times when that hasn't happened and somebody has ended up killed because that wasn't followed.
So now we're at the Buick. It's a Buick car, white car. Is that
It's a
right?
white car.
And now we're at the white car, and you three went up to it, correct?
Yes, Sergeant Johnson went
Where-
up to the
where did
passenger
Johnson
side.
go?
He went up the passenger side to provide cover.
And what does provide cover mean? Is
Keep an eye on the occupants of the vehicle and just to monitor what's happening outside in the world. See if
And-
people are walking up on you or things go wrong.
and where were you located?
I was towards the left rear corner of the car.
And where was Officer Lucky?
He was advancing to the driver's door.
And how, by the way, before this, how long had you known Officer Lucky?
I think we were on our 5th shift.
And he was pretty new arrival, was he? Or,
I believe he was in 2nd phase maybe, but he had been a police officer before.
okay, what does second phase mean?
He wasn't in his initial 4 weeks, he was in the start of his second 4 weeks. He was-
And you testified you knew, at least back then, that he had come from another police department, correct?
Yes, I think he worked at 2 previous agencies and he was an explorer.
Okay. Now let's go back to when you three arrived at the white car. We've already said where you're located. Officer Lucky was at the driver's door, is that right?
Yes, he would have been standing behind the post between the driver's door and the rear passenger door.
What do you mean by that, standing behind the post?
He wouldn't have been directly in front of the door because that would be an unsafe approach.
And this was this a warm day? Was the window down? Remember?
I don't know if the window was down or not.
Okay. But in any event, where were you standing again?
At the left rear corner.
And did you hear what Officer Lucky said?
Yes,
to-
I heard him ask the driver to step out of the vehicle a couple of times.
And did the driver step out of the vehicle finally?
Finally, he asked Officer Lucky a couple of times what was going on, and Officer Lucky said he would explain to him.
When he got out of the car?
Yes,
And so did the driver get out of the car?
yes.
And what do you remember happening next?
Officer Lucky had him turn around, and I think he was still asking what was going on. Sergeant
Who's he?
John,
Who's he?
the driver,
Go ahead.
and Sergeant Johnson and Lucky told him he was under arrest, and I told him he had a warrant.
Okay, so who said he was under arrest first?
Sergeant Johnson, I believe.
And Sergeant Johnson testified here. You remember that?
Yes.
And after he said that, did Officer Lucky say he was under arrest too?
Yes.
And you heard that?
Yes.
And what did you say then?
I told him he had a I told him he had a warrant.
You just said warrant.
I think so.
Did you specify what kind of warrant, if you remember? If you don't,
I don't think I would have. It wouldn't have been in my normal.
okay. So, what happened after Johnson and Lucky said you're going to be handcuffed or you're under arrest, and you said that there was a warrant? What happened next?
Officer Lucky had him put his hands behind his back, and I noticed that in the driver's right hand was something. It was paper or something, and I took it out of his hand and had it in my left hand.
And you had that in your left hand?
Yes.
And then what happened next? Strike that. When you did that, I take it you got closer to the driver?
Yes. I reached into the driver's hand and took out what he had in his right hand. And had it in
Right
my-
hand or left hand?
His right hand, and I held it in my left hand.
Okay. And what happened next?
Officer Lucky started to say something about, don't do that, don't tense up, stop doing that. And then it just went chaotic.
What do you remember happening after that?
I remember a struggle with Officer Lucky and the driver at the door. The driver was trying to get back into the car.
Well, he was trying to get back in the car. What did you do?
I went around Officer Lucky as they're trying to get back in the door. I'm between the door and Officer Lucky and the driver. And the driver's getting into the car.
And what happened next?
They're still struggling, and I can see Sergeant Johnson and the driver struggling over the gear shift, because I can see Johnson's hand, and then I can see his face.
And you knew Johnson for many years before this, is that right?
Yes.
And by looking at his face at that point in time, what did you interpret it to mean?
He had a look of fear on his face. It's nothing I'd seen before.
Did you say anything when you saw this? What did you do?
We were struggling. We were trying to keep him from driving away. It just went chaotic. And then I remember yelling, "Taser, taser, taser," and nothing happened. And then he told me I shot him.
Can you proceed, or do you?
Yes, it's fine.
Okay. After the driver said you shot him, do you remember what you said, or do you? If you don't remember, did you look at the video and see what you said, or do you actually remember what you said? I guess is my question. Not with help from a video.
I don't remember what I said.
And what do you remember next, if anything?
They had an ambulance for me, and I don't know why. And then I was at the station. I don't remember a lot of things afterwards.
Do you remember saying something about prison?
No.
If you did say that, do you have any idea now why you would say that?
No.
Was the climate back then about police officers a little rough?
Objection, Your Honor.
The objection is sustained.
All right. You don't remember saying it,
No.
and you don't know why you said it.
No.
Do you remember the response that our Sergeant Johnson or Major Johnson gave you?
No.
And when next do you remember what happened, if anything, if you remember?
I remember getting an ambulance, and then I was at the station.
Okay. And you remember being in the ambulance, arriving at the station?
No.
You don't remember the
No.
station?
I remember getting to the station.
Once you got to the station, do you remember what happened next?
The next thing I remember is Officer Fricky was in the room with me
And where were you located? Do you remember that?
in the front office.
Okay. In the front office room, do you remember, were you sitting down, standing up?
I was on the floor.
And after that, at some point in time, did your husband show up?
Yes.
At what time do you believe, from back there, April 11th, at what time do you believe that your memory came back to you?
Probably when my husband got there. So much of it is missing.
After that night, and for the last few months, have you been in therapy?
Yes.
And did you still work as a police officer there?
No,
Did you quit?
I did.
And this was your career?
Yes.
And when did you quit?
A day or two after the incident.
And why did you quit?
There was so much bad things happening. I didn't want my coworkers, and I didn't want anything bad to happen to the city.
And did you own a home in Anoka or Hennepin County at the time?
Yes.
You and your husband?
Excuse me,
The objection is relevant.
the objection is overruled.
Did you own a home, your family home, for years past?
Yes.
And did you sell it?
Eventually.
Before you sold it, did you move out of the state?
Yes.
And do you now live out of state?
Yes.
We have a moment, Your Honor. Thank you. I'm done, Your Honor.
Cross.
Good morning, Ms. Potter.
Good morning.
You've been a police officer, or were a police officer for 26 years. Isn't that right? You said you started in 1995,
Yes.
and that was with the Brooklyn Center Police Department for that entire career, right?
Yes.
And you said that you resigned from the Brooklyn Center Police Department, right?
Yes.
And that was on April 12th of this year, right?
Yeah, within a day or two of the incident.
Right after you had shot and killed Daunte Wright.
Yes.
And throughout that time period, you were a licensed peace officer, right?
Yes.
And to become licensed, you had to go through a number of requirements. Fair?
Yes.
You had a college degree.
Excuse me, Your Honor, the prosecutor speaking to that mic too.
Sure.
Thank you.
You have a college degree, right?
Yes.
And you also had to complete the peace officer education program, that skills component that you talked about.
Yes.
And that included skill sets and classroom training as well.
Yes.
You had to pass an exam to become an officer.
Yes.
And then you did all that before you started with the Brooklyn Center Police Department in 95, right?
Yes.
And then you got your license through the post board, correct?
Yes.
And that stands for Peace Officer Standards and Training.
Yes.
So you were licensed throughout that whole 26-year career, right?
Yes.
And you maintained all of the requirements to keep your license,
Yes.
including all the training that was required for it as well, right?
Yes.
And that training that's required for your license has all different kinds of components, true?
Yes.
You have things like use of force, use of firearms, tasers, all kinds of things.
Yes.
And you did all that training.
Yes.
And you did all that every year throughout that 26-year period, right?
Yes.
Sometimes multiple times a year, right?
Yes.
And all of those requirements were in place to make sure that you were at the beginning of your career and continued to be, competent and capable of performing the requirements of the job, right?
Yes.
You mentioned on direct that you were also a hostage negotiator as part of your duties, right?
Crisis negotiator.
Crisis negotiator. Did that involve some hostage-type situations?
I've never had a hostage situation.
Okay, but crisis negotiation.
Yes.
And that involved some de-escalation tactics, I presume, correct?
Yes.
And you had to develop that skill set and be pretty good at de-escalating situations as a crisis negotiator, fair?
Yes.
So you had some experience in stressful situations doing that?
No.
So you were a crisis negotiator but never experienced a stressful situation?
We talk to people.
Talk to people in crisis.
Yes.
And part of your job as a police officer is dealing with people on their worst days, right?
Yes.
People who don't want to cooperate with you sometimes, right?
Most of the people we talk to in crisis are either barricaded behind a door or talking to you from another room.
Okay. For 26 years you were a patrol officer, right?
Yes.
So you saw people out on the street every day as part of your job duties. Fair?
Yes.
And you talked about doing a lot of traffic stops during that career, correct?
I did some traffic stops.
Okay. Well, in some of those cases, there are people who have weapons, right?
Yes.
Sometimes people want to flee, right?
Yes.
Sometimes people are violent.
Yes.
And all of that's part of being a police officer, dealing with people in those situations, right?
Yes.
You'd agree that you're bound by policy and the requirements of the job that Brooklyn Center, the police department, sets for you, right?
Yes.
And you heard Commander Fleslin testify, but you had to acknowledge those policies and essentially agreed to abide by them every year you were an officer, fair?
Yes.
And you'd agree that your fundamental duty as a police officer is to safeguard life, right?
Yes.
And you also have the duty to never employ unnecessary force. True?
Yes.
Part of the policy also includes some of your responsibilities as an officer, right?
Yes.
And that includes being alert and attentive and capable of performing your job, right?
Yes.
And getting back to the training and sort of the post requirements, there's a lot of training that goes into being a police officer, fair?
Yes.
And we talked about a couple of those things, but one of those subjects is use of force, right?
Is that a yes?
Yes.
And use of force can include things like restraints, handcuffs, defensive tactics, chemical irritants, using batons, tasers, less lethal weapons, and firearms as well, right? All those things are options available to you. True?
Not all of them.
Okay, well, you carry a whole number of things on your duty belt every day, right?
Yes.
And that includes a firearm and a taser, right?
Yes.
And you also had other items on that duty belt as well, correct?
Yes.
And as part of the training that you went through every year, they cover topics of all kinds of uses of force, right?
Yes.
Including the things on your duty belt and maybe other options that the department could use additionally, true?
Only the things I was assigned on my duty belt.
Okay. But in any case, that use of force training was a pretty key component of being an officer, right?
Yes.
You were trained about when you could use force, how much force to use, and what would be appropriate force. Fair?
Fair.
And not only were you trained on that, but you had a lot of policy that that dictated what you could and could not do in a particular situation, right?
Yes.
And you were also trained on the readiness aspects of use of force, right? Being ready to engage whatever force might be required, right?
Yes.
Including making decisions under stress, right?
What do you mean?
Well, you had a lot of scenario-based training, right?
Yes.
And in those situations, those scenarios were set up to be as close as they could be to real life, right?
I suppose.
So you would be trained to have to make decisions in the moment about what to do and what force to use, right?
Well, it was a training situation, so it was usually slow and meticulous and controlled.
Well, you did this year after year, right, for the entirety of your career, correct?
I think scenario-based training started later, probably the last 10 or 15 years.
Sure, but use of force training has been around for a long time, right?
Yes.
Because since you started as a police officer, you have, in some cases, had to use force, true?
Yes.
And there are limitations on how and when to use that force, right?
Yes.
So you've had training on that throughout your entire career, right?
Yes.
And as part of that process, the way that it's required for you to maintain your license is that you sign in and you sign off on attendance forms, and you basically, you have to be there, right? You can't not be there, right?
Right.
And every year you have a certain number of training hours that are required, right?
Yes.
And you said on direct that you participated and you were paying attention during all those trainings, true?
Yes.
And some of those trainings had classroom instruction, PowerPoints, things like that, right?
Yes.
Some of them also included reviewing policies and other documents, right?
Yes.
And then there was also the hands-on training with the practical components, things like using drawing weapons, things like that, right?
Yes.
And over the course of your career, you completed many, many, many hours of training, right?
Yes.
And in terms of credit hours, we're talking somewhere in the ballpark of 1,700 credit hours. Does that sound right?
I don't know the number of hours, but if that's what you have, that would be probably right.
No reason to dispute that your training hours would have been in the thousands of hours over that 26-year career, right?
Yes.
You indicated that there weren't tasers available when you first started at Brooklyn Center, true?
No, they came in the early 2000s.
Okay. But in 1996, you had a firearm, right?
In 1995, yes.
Sorry, 95, and then you were sworn in 96, right?
No, I was sworn in February 27, 1995.
Okay. So in 95, when you first started, you had a firearm available to you.
Yes.
And you were trained to use that firearm.
Yes.
Trained how to handle it, right?
Yes.
Trained how to load it and unload it.
Yes.
Trained how to draw it,
Yes.
right? And fire it. And how to safely handle it, yes?
Yes.
And that included when not to fire it, right?
I suppose.
And that training started at the beginning of your career, you said in 95, but continued every year up until the time you resigned, right?
Yes.
Now, you indicated that tasers came later, but you were first trained on using a taser in 2002, correct?
If that's what the documents say, I'm not sure when they came out.
And if the documents say you were trained in 2002, you then would have been trained every year thereafter, right?
Yes.
And you started carrying a taser on your duty belt regularly as of 2005, right?
Yes.
But at a minimum, in addition to all the other training you had, you would have had taser training year after year for at least the last 19 years, right?
Yes.
And the taser training that's required, you saw the documents that were in court, also requires not only it requires review of policy, right? The taser policy, right?
Yes.
And it also requires practicing those reaction side draws, correct?
Sometimes.
All right, if we could put up Exhibit 334, please, the last page. I'm going to put on the screen what's already been admitted as Exhibit 334. And we're going to scroll down to the very last page. And highlight the subsection C, please. So, as part of the taser policy includes that all training should include performing reaction hand draws or cross draws to reduce the possibility of accidentally drawing and firing a firearm. That's part of the policy, right?
That's what it says.
And that's part of what you're trained to do, correct?
We didn't always we aren't always drawing our tasers from our holsters. A lot of times we were in plain clothes during training.
Okay. Well, your policy that you're required to abide by, that you signed off on, requires that you perform reaction hand draws, true?
During the training, yes.
It also includes the reason for that, right?
Yes.
And that's so that you reduce the possibility of accidentally drawing and firing a firearm, right?
Yes.
And we can take that down. Part of the reason for that is weapons confusion, right?
Yes.
And that was known in the field and has been known for a number of years. True?
I guess.
Well, you were trained on it, right?
We talked about it.
It was part of your PowerPoints, correct?
Yes.
You were made aware during PowerPoint after PowerPoint after PowerPoint that drawing and firing the wrong weapon can happen, right?
We were told it wasn't something that they expounded on.
You were told that.
Yes.
And you signed documentation every year you were certified acknowledging that you knew the risks, received and reviewed the materials required for you to carry that taser, correct?
Yes, I signed the documents.
Okay. Now, in terms of the carrying of these weapons, reaction side means what for you?
That'd be my left hand.
Okay. You're right-handed?
Yes.
So carrying a taser, you have done for years on your left side, correct?
Yes.
And your firearm you carry where?
On my right side.
How many years have you carried your firearm and your taser that way?
My firearm for 26 years and my taser, according to your documents, for 19.
So as long as you've had that taser, you've carried it on your left side, correct?
In the beginning, I carried it on my right side in a drop holster.
And when did you switch?
When we were given new holsters?
And when would that have been?
I don't know.
Okay. But far before 2016, you saw the images that were up in court. Long before that, you were carrying your taser on your left side, correct?
Yes.
Years and years, right?
Yes.
We talked a little bit about reality or scenario-based training. When you go through those trainings, you have available to you all the options that would be on your duty belt, right? Although inert for the purposes of training, right?
Yes.
And the purpose of that training is to try to recreate real-life stressful situations as best as possible to practice making those types of decisions in the moment. Fair?
Fair.
Let's talk a little bit about your taser. You'd agree that the Taser 7 that you have and the taser you had before that has a safety mechanism on the side of it, right?
Yes.
And you have to flip it up to arm the taser.
Yes.
And when the taser is on and armed, it beeps, right?
I don't know if it beeps.
There's a display screen that turns on.
Yes.
And then there are two lasers with the Taser 7 that appear on your target, right?
Yes.
A green one for the top probe, right?
I believe so. It was a new taser.
And a red one for the bottom.
I would guess so, yes.
Well, you were trained on it, right?
Yes, but it was a while back.
Well, you were trained in March of this year on that taser, correct?
Yes.
And you had to successfully operate and handle that taser in order to be certified to use it, correct?
Yes.
And you went through that hands-on process of turning on that taser and safely handling that taser in order to be certified, correct?
Yes, in March.
In March. And before that, you had an X26P, correct?
Yes.
And that taser also had a laser and a safety and things like that, right?
Yes.
The screen that turned on.
Yes.
And the taser, and that was the taser that you had been carrying for years before, right?
Yes.
Very similar to the Taser 7. in that way?
Similar but different.
All right, so I'm going to put on the screen next to each other, please, Exhibits 210 and Exhibit 212. Now, this is a picture, side-by-side pictures of you on April 11th, correct?
Yes.
And your taser is pictured on the left side of your duty belt, correct?
Yes.
And that's the way you'd been carrying it for years and years, correct?
Yes.
And your firearm you carried on the right side of your duty belt, right?
Yes.
And you'd agree that the standard procedure for a reaction side, left-hand draw for your taser in this case, would be to draw that weapon with your left hand, correct?
Yes.
All right, you can take that down. You were asked some questions on direct about spark testing, the function test of the taser. The policy says that you should do that before the beginning of every shift, right?
Yes.
And you didn't do it the last 2 shifts that you worked, correct?
That's what the documents say.
Right. You didn't do one for the last 4 of your last 10 shifts that you worked, in fact, correct? If that's what the documents say.
Which dates?
You didn't do it on March 27th, correct?
I guess.
You didn't do it on March 28th.
Your Honor, I object to this cross-examination if she doesn't know.
All right. Okay, one-word objections, please. If she doesn't know, she can say she doesn't know.
If the documents show that you didn't do a spark test 4 of your last 10 shifts, you have no reason to dispute that, right?
No.
And the day of this incident on April 11th, you didn't do a spark test that day, right?
No. According to the documents.
And even though, that day was a slow and uneventful day at the beginning of the day, right?
I don't know. I don't have a log.
Well, you told Dr. Miller that that day started as a slow and uneventful Sunday, right?
I don't know if I did or not.
Council sidebar. Okay, you may continue.
All right. So April 11th started as a slow and uneventful day, right?
I guess it's a Sunday.
Okay. I'm going to put on the screen Exhibits 224 and Exhibit 178 next to each other, please. All right, Ms. Potter, on the screen are Exhibits 224 and 178. You'd agree that these are photos of your taser and your firearm, respectively, yes?
My firearm for sure. I'm not sure if that's the taser that was taken that day, but I'm guessing it is.
And you carried a Taser 7 that day, correct?
Yes.
And that's what's in this picture, Exhibit 224?
Yes.
Now, these items look different, don't they?
Yes.
Your Honor's argument is
The objection is overruled. I think you answered. Did you answer? You may answer if you didn't.
Yes.
And just to be more specific, the taser is yellow, right?
Yes.
The firearm is black, correct?
Yes.
The taser weighs about half as much as your loaded Glock, right?
I don't know.
Doesn't weigh the same, correct?
That's what they testified to earlier, but I don't know.
When it comes to the Taser 7 that you had just been recertified on or certified to use, your department used long-range cartridges for that Taser 7, correct?
I don't know.
You were trained to use it, correct?
I don't know now. I don't remember.
You don't remember being trained to use the Taser 7 at all?
No, I remember being trained, but I don't remember today what cartridges we were issued.
Okay. So you went out on the street with the taser, not knowing what that taser did?
I would assume that on the day I worked I would know, but I don't know. It's been months now.
Okay. No reason to dispute that the Brooklyn Center Police Department used long-range cartridges in the Taser 7, correct?
No.
And the reason to do that would be so that you could fire at a farther distance with your taser, and you wouldn't need to approach someone up close, correct?
I don't know. I would assume so, but I'm not positive.
Well, that's why someone would use a long-range cartridge as opposed to a short-range cartridge, correct?
Yes.
Okay. And you've been trained on tasers since 2002, correct?
Yes.
You know how they work, right? And you know
Yes.
what they do. Could we take those down, please, and put up Exhibit 214? Okay, Exhibit 214 that's been admitted is on the screen. Is this a picture of your duty belt?
Yes.
You'd agree that the holsters for your taser and your firearm are different, correct?
Yes.
And your firearm holster is empty in this picture, right? There's no firearm in it.
Correct.
Is that this right here?
Yes.
The taser holster is made of plastic, right?
Yes.
You have to push a button, this button right here, and rock it back to get it out of the holster, correct?
Yes.
And your gun holster is made of leather, is that right?
Yes.
And it has a little snap, is that right?
Yeah. Yes.
And how does that gun come out of that holster?
It would rock forward.
How do you pull it with your hand out of your holster?
It would rock forward and you would pull it up.
Okay. And the taser, on the other hand, you would depress the button, rock it backward, and pull it up, correct?
Yes.
All right, if we could take that down, thank you. Now, you testified that you have never deployed your taser or your firearm while on duty out on the street, correct?
Not that I recall. I know for sure my firearm.
Okay. But you have drawn your taser multiple times while on duty, correct?
Several times.
And you said that you did that as a way to de-escalate. I believe that was your testimony on direct.
Yes.
And approximately how many times did you pull your taser but not deploy it while on duty?
For de-escalation, maybe a few times.
Now, there are a couple times that you pulled your taser and didn't deploy it. One was in 2013, correct? No reason to dispute that it happened once in 2013 at least?
I would guess no reason.
There was a situation where one of your colleagues, a former officer, was hanging on the back of an individual, and you pointed the taser at him, but didn't tase him because you would have tased your fellow officer. Is that right?
If it's the one I'm thinking, yes.
And instead of
She was on his back.
deploying your taser, you called for extra help, correct?
Yes, and we probably continued to fight with him.
You never deployed your taser then.
No.
There was another incident in 2016 where someone was not complying with commands to place them under arrest, right?
I don't know what event you're talking about.
Well, in this case, there was an individual who was struggling, a female individual. She didn't want to get in handcuffs, and then one of the officers took her down to the ground by force, correct? And you pointed your taser but didn't deploy it, right?
If that's what the documents say, I don't recall the incident.
Okay. But you recall that you have drawn your taser and not fired it in your 26-year career.
Yes.
All right, I'd like to talk a little bit more about April 11th. So, on April 11th, you were serving as an FTO, right?
Yes.
And you said that you have done that for 10 or 15 years.
For many years. I don't remember when I got certified, but it's been many, many years.
Okay. And you said that on direct, I believe your testimony was that you had knowledge to impart and that mentorship skills that made you suited for that job, right?
Yes.
So you were serving as Officer Lucky's FTO on April 11th. How long had you been his FTO?
I believe it would be 5 shifts. It would have started the Monday after Easter Sunday.
Okay. But you were essentially in a supervisory position, right? Serving as his FTO?
Yes, I guided him.
It's a big responsibility, true?
Yes.
You have to be a good example, sort of set the stage for what a good police officer should do in any particular situation, right?
Yes.
And to do the job of an FTO, you have to be really familiar with policy and training and proper uses of force, right?
Yes.
And you have to make sure that someone else is doing it all right too, right?
Correct.
And you testified that that morning, the morning of April 11th, you reviewed pursuit policy with Officer Lucky, correct?
That afternoon.
Okay. But that pursuit policy includes not shooting at the driver or occupants of a vehicle, right?
A moving vehicle.
And you told Officer Lucky, we're not in the city, right? Did you tell Dr. Miller that you told Officer Lucky in reviewing pursuit policy, you used the phrase, we're not in the city?
Because we're on Zane Avenue, which is in Brooklyn Park.
And why did you say that?
To remind him of geographical boundaries.
And you were also reminding him of the limitations of the pursuit policy, correct?
What do you mean?
That you can't just get into a high-speed car chase or shoot up a car without specific reasons, right?
Yes, for our pursuit policy limits what we can pursue for.
And a gross misdemeanor warrant doesn't qualify for a vehicle pursuit, right?
Not according to our policy.
And you had just reviewed that policy with Officer Lucky that day, correct?
Yes.
So getting to what happened with the stop, you said that there was a turn signal misplacement, perhaps. You saw the wrong turn signal. That was the first thing that you saw?
Officer Lucky saw it first.
Okay, so you didn't see the wrong turn signal. But after that, you saw the air freshener, right?
I saw the expired registration.
Well, you had said on direct that you would not have pulled that vehicle over, right?
Probably not.
And you said that you knew that there had been some delays because of COVID with people getting their tabs up to date, right?
Yes.
But you also mentioned the air freshener to counsel on direct, didn't you?
Yes.
But regardless, expired tabs, air freshener, this is the kind of traffic stop that is pretty routine for you in your 26 years as a cop, right?
No traffic stops routine, but it would have been something I would have done several times.
I'm sure you've seen lots and lots of cars with air fresheners and expired tabs. True?
Yes.
And then the decision was made to pull over the car. You mentioned that there was some information that maybe there was some other warrant that you learned about around that time. You didn't discuss any of that with Officer Lucky, did you?
He would have had the same warrant hit that I would have heard.
None of that was mentioned. None of it was even worth discussing with Officer Lucky at the time you pulled over the car. Fair?
I don't remember if we talked about it or not.
Okay. But in any case, you pull over the car, and Officer Lucky approaches the driver's side, approaches Mr. Wright, right?
Yes.
And he came back to the car with a name, date of birth, all kinds of information, right?
I know a name and a date of birth.
Well, Officer Lucky told you that he believed him. He thought that essentially that Mr. Wright was telling the truth, right?
Yes.
And then when Officer Lucky put in all this information into the system, you corrected him, you admonished him, you told him he was doing it wrong, right?
I told him better ways to do it, probably.
And that's your job as an FTO, right?
Yes.
To correct him if he messes something up, right?
Yes, when there was an opportunity.
So you corrected him, and then he re-entered the information, and then you found out about the warrant, right?
Yes.
Now there was also a conversation about Officer Lucky code 4ing himself, right?
Doing what?
Code 4ing
Oh,
himself.
code 4ing, yes.
And did you also correct Officer Lucky for doing that?
He did it before he ran the driver, and he shouldn't do that.
And you told him that, right?
Yes.
Don't code 4 yourself before you have all the information. Something to that effect, right?
Yes.
And again, that was your job as the FTO to correct whatever he was doing that was wrong, right?
Yes.
So you got this information and then made this decision to go arrest Mr. Wright, correct?
Yes.
And you didn't talk about going out there with guns drawn or anything like that. You didn't talk about using force on the approach or anything like that, right?
No.
And then Officer Lucky pulled or asked Mr. Wright to get out of the car, which he did, right?
Yes.
And you stood back and watched this happen, correct?
I was just a couple feet away.
Okay. But you didn't correct the way that had happened. You didn't tell Officer Lucky to move or to put Mr. Wright somewhere else, right?
I wouldn't do that to a rookie in front of a suspect.
Okay. But you didn't do it regardless. Didn't happen.
No.
And then as you approached and got closer, was there a moment that you got closer after things didn't quite go the way you had hoped they would go?
I got closer before that happened.
Okay. And you'd agree that you unsnapped your gun holster as you approached, right?
No, I wouldn't agree to that.
All right, if we could put on the screen Exhibit 12, just the still image at 2:01:20, please. And zoomed in on, yes, the squad car view. You see yourself in that picture,
Yes.
and you see your right hand on the right side of your duty belt.
Yes.
And is your right hand on your firearm here?
It's blurry, but it's possible.
Okay. We can take that down, thank you. All right, so As you approached, and Mr. Wright got out of the car, was there a moment where it appeared that Mr. Wright was going to flee or attempt to flee?
When he started struggling with Officer Lucky.
Okay. And ultimately, was Mr. Wright able to get back in the car?
Yes.
You never saw a weapon on Mr. Wright, did you?
No.
Never saw a gun?
No.
He never threw a punch, right?
No.
Never kicked anyone?
No.
Never said, I'm going to kill you?
No.
Never said, I'm going to shoot you?
No.
Never said, there's a gun in the car and I'm coming after you?
No.
Okay. It's not uncommon in your experience to find someone who has a warrant during a traffic stop, right?
It's not uncommon.
And you've done hundreds of traffic stops in your career, correct?
I don't know if hundreds, but yes, I've done plenty of traffic stops.
And gross misdemeanor offenses are not the same as felony offenses. Fair?
Correct. They're different order by the judge. for
Less
the crime.
serious crimes, correct?
All crimes are serious, but yes.
Well, in terms of the laws of the state of Minnesota that you're duty-bound to enforce, a gross misdemeanor is a lesser offense than a felony, correct?
Yes.
And you don't get to shoot someone because they have a gross misdemeanor warrant, correct?
Not for.
Your Honor, it depends on the circumstances.
Okay, the objection is sustained.
As
The
the
jury
jury
will disregard that question.
You also testified about learning about an order for protection, correct?
Yes.
You said it was a temporary one that you saw, correct?
I believe it was an ex parte order.
And essentially, the order that you're describing would limit contact between two people, correct?
Yes, in various ways.
It doesn't prohibit all contact with all members of the opposite sex, right?
Just certain parties that they're not supposed to have contact with.
Right. And you'd agree that half the world's population is female, right?
I suppose.
So just having a female passenger in your car is not in and of it and by itself a violation of an OFP, correct?
It has to be investigated.
Sure. And you did not see a need to rush up to the passenger side of the vehicle and pull this woman to safety, right?
Not at the moment.
Okay. Now, there was also some conversation, as you saw in the videos that were offered in court in this case, conversation about the Wright brothers. You made a comment about the Wright brothers joking about not the ones that fly, right?
Yes.
And then any concerns about whether there was some other Wright family in the area, Sergeant Johnson told you, not that family, not this situation, right?
I wasn't sure who they were.
Okay. But he didn't cause you any greater, he didn't tell you this is the family we should be concerned about. You got to be worried about this guy, right?
No, he didn't say anything like that.
Okay. And when you got over to that car and Mr. Wright got back into the car was still running, right? It was running that whole time?
I don't know if it was on or not.
Well, you told Dr. Miller that the car was running, didn't you?
I don't remember that.
You told Dr. Miller that Wright pulled away and got back into the driver's seat of the car, which was still running.
Okay, then I said that.
And the entire time this is happening, you're standing behind Officer Lucky, right?
At what point?
As Mr. Wright is getting back in the car.
I came around Officer Lucky's left side to help him.
And you indicated that Sergeant Johnson had approached on the passenger side, but he wouldn't have been in front of the door because that would have been unsafe, right?
Yes.
Okay. I am going to put on the screen Exhibit 13, starting at 2:01:48, just that, if you could just leave it with that time frame, please. Okay, Ms. Potter, on the screen we have Exhibit 13 at 2:01:48. I'm going to slowly advance the frames and then pause it periodically. So let's advance just a bit. Okay, stopping right there. At 2:01:48, do you see yourself here taking a piece of paper in your left hand?
Yes.
All right, now advancing to 2:01:49, please. Okay, now stopping at 2:01:49, do you see that you've transferred that piece of paper to your right hand?
It looks like it.
You can advance a little further, please. Okay, would you agree that the piece of paper at 2:01:49 is in your right hand?
I don't know where it is.
Is this the piece of paper right here?
Yeah, it's a piece of paper.
All right, let's advance a couple more frames, please. Okay, stopping right there. Would you agree in this frame of 2:01:49 that the piece of paper is in your right hand?
Yes.
All right, and if we could play stopping at 2:01:54, please. Okay. And then if we could advance a few frames, please. At this point, the paper is in your right hand, correct?
It appears that way.
And then at 2:01:55, we could stop right there. You've just transferred the paper back to your left hand, correct?
That's what the video shows.
Okay. And then if we could advance a few more frames, please. To 2:01:56. A couple more frames, please. Okay, you'd agree at 2:01:56 the piece of paper is still in your left hand, correct?
Yes.
Okay, let's advance. Actually, let's play until 2:02:01, please. Okay, so stopping at 2:02:01. You have the firearm in your right hand, correct? Yes. And you are pointing it directly at Mr. Wright, correct?
Excuse me, Eric, we have a break. My client is...
Okay. Miss Potter, do you need to take a break? Okay. It's moving away, so... Okay, members of the jury, we're going to break for lunch, and we'll start up again at 1:30, okay? Yes, Julie, step down.
Hello everyone, Tim Blotz in the Fox 9 studios. You've been watching our special coverage this morning of the trial of Kim Potter for first and second degree manslaughter in the shooting death of Daunte Wright from that traffic stop that happened last April 11th up in Brooklyn Center. You've just witnessed some emotional moments on the stand as she's taking the stand in her own defense, recalling the moments that led up to the shooting. And you saw the second point here in testimony this morning where she's asked to look at the videotape and at least re-describe what happened. And of course, that resulted in us taking a lunch break right now. Earlier, under initial exam by her attorney, Earl Gray, I should say, she described the moment that it happened and the look of fear on the face of Sergeant Johnson, who was reaching into the car to try to disengage the shift mechanism to keep it from driving forward. She said, "We were trying to keep him from driving away. It went chaotic. I remember yelling, 'Taser, taser, taser.' And then something happened, and he told me I had shot him." And that's when she broke down into tears. Earl Gray asked her if she needed a moment, and they continued on. So we are going to take a short lunch break here. These typically last about an hour. We are going to wrap up our coverage here on Fox 9. For the moment, return you to special programming for all of you who want to continue on the live stream on fox9.com and on our YouTube channel. My colleague Paul Bloom will join us along with Debbie Lang, our legal analyst here, to look at this trial so far this morning and replay some of the key testimony from Kim Potter as she took her own defense. In the meantime, for all of our viewers on Fox 9, we are going to now return you to special programming, to our programming that's on the air, and we will return with our special programming here when the jury returns. Thanks for joining us. To all of our streaming viewers, thank you for a moment while we signed off on Fox 9. We're going to continue our coverage right now on fox9.com and on our YouTube channel. I want to bring in Paul Bloom and Debbie Lang, who have been watching all of this. Paul, I'm going to start with you. We knew this would be some powerful testimony this morning, and I think one of the things that struck me is I expected Earl Gray to ask more questions.
Yeah, it's a lot to unpack there. So I think if we slowly go through this now, and I know Debbie Lang, our criminal defense attorney, of course, unaffiliated with the case, about to join us shortly. But my first thought initially was it was shorter than I expected. It went about 45 minutes under direct examination. I think Earl Gray just wanted to get some biographical information on there and then really get at what happened on April 11th. A couple key points I would just take away, again, headlining it. There is just so much here. First, in terms of the traffic stop, I just thought it was an interesting note that she probably wouldn't have made that traffic stop if she was riding alone that day, that she sort of deferred to her training officer who wanted to make the traffic stop. He saw the wrong turn signal on the car in the wrong lane, notices the air freshener, notices the expired tabs, and then they process the ID. They notice the arrest warrant, the order for protection, and so forth, and that escalates from there. But obviously, the idea that Kim Potter, probably deep down inside, as she thinks about what happened that day, says to herself, "I wouldn't have even created that traffic stop." I just thought it was an interesting note. Of course, Tim, you mentioned the fear she sees on Sergeant Johnson's face leaning into the car from the other side. We didn't know what she was going to say about her perception of Sergeant Johnson reaching and holding on to the gear shift, trying to grab Daunte Wright, holding Daunte Wright's passenger back. We didn't expect, or I didn't necessarily think about that. Oh my God, I saw the fear on his face. I've never seen it before. So that idea is sort of building up into her mind. And then there's a blank slate. Let's be honest. She doesn't remember some things that kind of unfold in those seconds. I know we're talking seconds. I can't imagine a human being going through this experience, but it's sort of blank in there. There's some key parts where we wanted to kind of know what's happening in your head, and I just guess the jury isn't going to find out. So with that, let me just bring in Debbie Lang, again reiterating here, a criminal defense attorney here in the Twin Cities, Hallberg Criminal Defense, but very much important to point out to our viewers on the stream that she is not affiliated at all with this case. And Debbie, I was saying to Tim, I just think there's a lot to unpack, so I don't want to create a broad question for you, but you're a criminal defense attorney. You've put your clients up on the stand today. Why don't you start with just how you see Kimberly Potter being perceived by this jury? There was a lot of emotion there, but she also, went through the details, left open the idea that there's some seconds in there she doesn't remember. Your sort of quick assessment of Kim Potter up on the stand.
So generally, I think her emotion came out obviously at the appropriate time. Prior to that, she was coming across one may say cold and stoic, others may say very professional in terms of talking about her career. But her emotion certainly came out, and I believe it came across genuinely. I don't think that was something that she had practiced doing. It came out when she got to the relevant incident on the 11th. I did agree. I heard, Paul, that you'd indicated that you were surprised that the direct examination was so short. I agree with that. I was surprised that they didn't have Kimberly Potter talk more about the things that she was testifying to. Specifically, she noted that the fear in Sergeant Johnson's eyes, or his face, she hadn't seen that before. But her attorney didn't ask her to continue with that thought. What did that tell you? What did you think? What did that make you feel? Her emotion as she made that statement, it's clear right now she's frightened. It is upsetting to her. But I was surprised that her attorney didn't ask her to talk more about that, because that's so important when we're addressing the appropriate use of force, whether or not she thought herself or the other officers were in fear of or in harm's way for great bodily harm or death. So simply indicating that there was fear, I'm surprised she didn't go further there.
Deb, Tim Blotz here. You keyed on that moment of testimony that I thought was so important to her defense in that dual track defense that they're now taking about perhaps the authorized use of force, because they felt at the scene, or at least she may have felt at the scene, that her fellow officers were in danger, which under Supreme Court cases we know can justify the use of deadly force. But in this particular moment, I think what's important, this is the first time we're hearing from Kim Potter on this matter. We've heard from her attorneys trying to make this defense. This is the first time that we are hearing from her as to what she saw, because up until this moment, we did not know if she saw Sergeant Johnson inside the vehicle.
Right, and that's exactly why, Tim, I think it's important, and why it surprised me that there wasn't more discussion about that. I recognize and understand that she has moments that she can't recall, and she has lapses in her memory surrounding this incident. That doesn't surprise me one bit. But when she makes a statement that she sees the fear on Sergeant Johnson's face, that is an ideal moment to talk about what that means and what she interpreted that to mean in terms of her training and its relevance in connection with her ability to use of force, deadly or otherwise.
Debbie, well, if the defense explores that, then isn't the next question, why didn't you pull the gun on purpose? If you saw that fear, it's a life and death situation. You have to end the threat. Why not go to the gun? Why go to the taser, given the totality of the circumstances, him behind the wheel? I know she insists it's not in motion, but if it's a life and death situation, don't police pull the gun?
And she certainly could then go back and say her training, that she's been trained to de-escalate. That's something that she'd always done throughout her career. And that was why her intention was to grab the gun to de-escalate. And then she could discuss what that means and what she thought would result as a reaction of pulling and then deploying that taser. Again, I'm speculating here because obviously I've never spoken with Kim Potter, and I wouldn't. But here, it's an opportunity where she's talking about that fear. So I'm surprised the defense didn't run with it more to be able to, again, even justify the use of her taser and let her explain why she wanted to use a taser. And I'm surprised. So I'm definitely interested to see where the state is going to go with this, or if they are going to stay away from that statement altogether, seeing as the defense didn't go further.
Debbie, we've talked about how some of her testimony may help her own defense, but let me parse out for a little bit now how some of the cross-examination helped the state's case in their charges of manslaughter 1 and manslaughter 2. And in particularly, Aaron Eldridge, the state's attorney there, got her to, in fact, I copied some of this down, you agree that you were bound by police policies at the Brooklyn Center Police Department? She said yes. That you agree that your fundamental responsibility is to safeguard life, right? She answered yes. When she talked about policies, these are policies you agreed to. Yes. You were told time and time again that drawing with the wrong hand could result in an accident. Yes, during her training. So they're trying to build their case to the jury that she violated department policies, which is really kind of central to the charges.
Absolutely. And something else that Ms. Eldridge did, piggybacking on that, which I thought was very good, is that she brought up specific examples of when Kim Potter has pulled her taser. She didn't deploy it, but she pulled it. And Ms. Eldridge went through and really painted a picture of that scenario. And what she was doing, in my opinion, was trying to show that those situations as well were chaotic. That was the term that Kim Potter used when describing what happened on April 11th. And so Ms. Eldridge is painting a picture there of a situation where her colleague, another officer, is hanging on the back of another individual. And again, that you can imagine that scuffle. And Kim Potter pulls a taser but doesn't deploy. Similarly as well, there's another situation where a female in 2016 did not want to be handcuffed and is physically resisting with another officer. Again, in that situation, Kim Potter pulls her taser but doesn't deploy it. So I thought that was a very good play by the state, particularly because they need to try to contradict when Kim Potter's saying this was so chaotic on the 11th. Here's what I did. I made this mistake, yet we have other chaotic situations where she didn't. So I thought that was some good cross-examination by Ms. Eldridge.
And I would agree, Deb. I think Aaron Eldridge so far is doing pretty well in terms of cross-examining her. The attitude on the stand, I know the emotions there. I don't necessarily like the body language as Aaron Eldridge is questioning. Just my quick assessment, again, on TV screen. I am not in the courtroom, but I think Eldridge is kind of meticulously sort of proving the state's case, or attempting to, based on the charges, and putting the two weapons side by side. I mean, I know it's pretty obvious to the eyeball that there's a yellow and black taser, there's a handgun. The handgun's heavier, the different size. We've gone all through that, but seeing that with the defendant on the stand is got to be a powerful scene in that courtroom for the jury to process that. And the only other thing I do want to kind of mention here is some of the pool notes that we've gotten now on the break. We're just wondering about, how the jury is taking it all in, and then seeing note taking, and then people not distracted, not dozing off, needless to say. But the emotion portion here at the end, you saw Potter's attorney step in and ask for the lunch break. She'd been on the stand for about 90 minutes, 45 minutes under direct, 45 minutes under Aaron Eldridge's cross-examination. She was getting upset there. And in the back of the courtroom, Katie and Aubrey Bryant, Daunte Wright's parents, are back there, back of the room holding hands. Katie Bryant crying as the video is advanced frame by frame, that body camera footage. Aubrey takes her hand and tears up too. So that courtroom obviously filled with so much emotion, both up on the witness stand and then obviously in the back of the courtroom as the family watches that. So as we come back, everybody will collect their thoughts. We go back up there. Where else, Debbie, do you think the state needs to go as they come back? What other areas of Potter's story do you see them trying to tackle? Again, we heard her, and I know I've asked you about this a lot, the "I'm going to prison" line that she doesn't really recall saying, but Earl Grey tried to lead her down the road of that, police and current state of affairs. Obviously, this happened right in the middle of the Derek Chauvin trial. And I think they tried to talk it away along those lines. But I would imagine Aaron Eldridge is going to press her on, what do you mean you're going to prison? If you saw all that fear in Sergeant Johnson's eyes and you saved his life, why wasn't that top of mind at the moment?
I absolutely believe that the state will go at Kim Potter for that specific statement. And that's exactly the reasoning behind it, Paul. I agree with that entirely. They're going to be talking to her about, the statements about being suicidal, the statements about going to prison, her reaction, which, was extreme. And, she continued to say over and over again, oh my God, oh my God. And so those statements are definitely going to be highlighted by the state. And I suspect Kim Potter's response, and she will likely be emotional as the prosecution continues to cross-examine her about the aftermath and those statements. I think Kim will begin to get emotional again, but I expect the state will forge ahead and they will continue on that path, because it is very important for the exact reasons that you stated. It contradicts the defense's argument that Kim Potter was justified and she knew what she was doing at the time when this occurred, in terms of trying to deploy the taser.
Debbie, Tim here. I think another instance here under cross-examination that was effective for the state is trying to eat at the defense argument that she could have been authorized to use force. And under direct questioning from Aaron Eldridge, when she said, "You never saw a weapon on Mr. Wright, right?" And Kim Potter said no. There were a couple more questions, and she finished it off by saying, you never said there's a gun in the car with the subject saying, "I'm coming after you." And Kim Potter said no.
Yeah, I agree, Tim. And Ms. Eldridge went further as well in that train of thought when she was talking about the pursuit policy that Kim Potter reviewed that very day with her trainee. And Ms. Eldridge specified that a gross misdemeanor warrant pursuit is not allowed pursuant to policy that was reviewed that day. Additionally, during the cross-examination, Ms. Eldridge had asked about unsnapping her firearm. And Kim Potter said, "I don't remember doing that." And Ms. Eldridge put up a still photo of that. I was a bit surprised she didn't play the video, which may make it more clear, because the hand simply being on a holster does not indicate that it is going to be unsnapped. However, the video would show that more clearly. So I was a bit surprised that she didn't show the video in that regard when Kim Potter said that she didn't recall unsnapping her firearm.
All right. Debbie Lang, who's one of our legal analysts here from Hallberg Criminal Defense in town. No connection to this case at all. Debbie, we thank you for your continued legal analysis and helping us understand this. We are right now in the middle of our lunch break, and we're about 20 minutes into it already. This typically goes for about an hour each day. We do expect the court back with more cross-examination of Kim Potter at about 1:30 Central Time. In the meantime, we want to take you back to the very beginning of her testimony on the stand. She's being questioned by her attorney, Earl Gray, laying out her training in law enforcement and how she got into it. So let's take you back to Kim Potter, now on the stand from earlier today.
I have to perjury that you will truthfully answer questions.
I do.
This case.
I do, Your Honor.
Please have a seat, and please remove your mask. And Ms. Potter, I gave the rules for testifying, and you've been in the courtroom. Do you need for me to repeat them?
No, Your Honor.
Okay. State your full name and spell it.
Kimberly, Kimberlyann, Potter, Potter.
All right, counsel.
Thank you. Ms. Potter, will you speak into the mic, because both of your lawyers have a hard time hearing?
Yes, there's just Kleenex here.
Okay. You stated your full name. How old are you, ma'am?
49.
And are you married?
Yes.
And is your husband in the courtroom?
Yes, he is.
And what's his name?
Jeff Potter.
And how long have you been married?
Over 25 years.
And when did you first meet your husband?
When I was 15.
And you were in high school?
Yes.
And did you reunite much later?
Yes, when I was in college.
And what does your husband do?
He works for a healthcare system now.
Is he a retired police officer also?
Yes, he is.
And where was he a police officer?
Fridley, Minnesota.
Was he also a member of a drug task force?
Yes, he was.
And with respect to your children, do you have children?
Yes,
And what are they, 2 boys?
I have 2 boys,
And what are their names?
Nicholas and Samuel.
And are they in the courtroom?
No, they're not.
And where is Nicholas?
He's an active duty Marine.
And where's that at?
He's currently stationed in Florida.
And your other son, where's he at?
He's in college in North Dakota.
And are they going to be home for the holidays?
Yes, they will.
Is your mother in the courtroom?
Yes.
And your sister?
No, she's not.
But is your brother in the courtroom?
Yes, he is.
And besides your brother and your mother, your father is deceased?
Yes.
And do you have any other siblings?
I have another sister and a brother.
And what are they? Do you know what their ages are?
My sister, my oldest sister's in her 50s, and my other brother's in his 50s also.
And what do they do for a living?
My sister works for a medical device company. My oldest brother works for a parking company, and my other brother works for retail.
Going back to when you were a youngster, where did you go to elementary school?
Immaculate Conception Catholic School,
And where was that located or is located?
Columbia Heights, Minnesota.
And did you live in that neighborhood?
Yes, I did.
While you were at elementary school, while you were going to that school, did you have a police officer visit your school?
Yes.
And do you actually know his name today?
Yes, it's Officer Michael McGee,
And where was he a police officer
the
at?
Columbia Heights Police Department.
And why was he at your school?
He was doing bicycle safety for grade school kids.
And you remembered his name. Anything else that was significant about him that caused you to do something in your life?
He was, on that occasion, he really influenced me as a youngster that the police are good people, and I wanted to be something like that someday.
And because of that, and because of him being at your school, did you start out doing that?
Yes.
And what was your first job or volunteer work as some type of a law enforcement officer, student, explorer, school cop?
Well, the first thing I did was when junior high, was a school patrol officer, if that counts.
Yes, that does count. And what did a school patrol officer do back then?
It was junior high, so we helped the younger grade school age children get across the street.
And did you continue to do that throughout junior high?
Yes, 6th, 7th, and 8th grade.
And after getting into high school, what did you do?
The Fridley Police Department came to my high school and had a booth set up for the Fridley Police Explorers.
And did you join the Explorers?
Yes, I did.
Why did you join the Explorers? First of all, what is an Explorer?
It's part of the Boy Scouts of America. It's a area where you can have career enhancement, or you can learn about different jobs like law enforcement or firefighting, things of that nature.
And were you an explorer throughout your high school days?
Yes, I was.
I can't remember if I asked you what high school you went to.
Totino Grace High School in Fridley.
With respect to criminal justice or law enforcement, while you were in high school, besides being an explorer, did you do anything else?
I had jobs.
Okay, what was your job?
My first job was at a gas station.
What did you do there?
Clerk, cashier.
And did you continue that job throughout high school?
Yes, and into college.
Okay, so your next visit was college.
Yes.
Where did you go to college?
St. Mary's College in Winona, Minnesota.
And that's about, what, 70 miles from here, 80?
Yeah, it's down towards La Crosse.
Okay, it's in Winona.
Yes.
And what was your major at St. Mary's?
Criminal justice and sociology with an emphasis on elderly studies or geriatric sociology.
Why did you take those courses?
I wanted to go into law enforcement, and I had an interest in serving the older community and understanding their needs and wants.
Did you graduate from St. Mary's?
Yes, I did.
And was that a 3-year program, 4
It was a
years?
4-year program. I finished it in 3.5 because I had an internship in the summer.
And where did you internship?
The Columbia Heights Police Department.
Columbia Heights Police Department?
Yes.
Okay. And what did you do at the Columbia Heights Police Department?
I was assigned to an officer who was in their community-oriented policing program.
Did you also continue your Explorer career while in college?
I stopped being an explorer after my freshman year, and then I role-played at the annual conference.
What does that mean?
Every year, the Explorer program had an annual conference at Breezy Point Resort, and they needed role players, and they like to use students or people that were in law enforcement.
So, you graduated from St. Mary's,
Yes.
and what did you do after that?
After that, I would have gone to Skills in the summer of 1994.
Okay, and what do you mean by that?
I went to Skills.
What does that mean?
I went to the police certification program so I could get hired.
And where was that at?
Alexandria Technical College?
In Alexandria, Minnesota?
Correct.
So everybody knows about 120 miles, 30
Yes.
from here. And did you stay there while you were being educated?
Yes.
What kind of a program was that? How long was it?
It was 10 or 12 weeks.
And what do you mean? Is that where you obtain your skills to apply as a police officer?
Yes, it was a hands-on training. I had the college education, the book knowledge, and then I went there for my skills program or my hands-on part from getting my license.
After this program, did you go out and try and get a job in law enforcement?
Yes, I did.
And were you successful at first?
Yes.
Well, did you have a job at Anoka?
Yeah, I worked at the Anoka Metro Regional Treatment Center because I graduated in January, in December. I couldn't go to Skills until the next summer, so I got a job.
All right, but you worked Skills, you were in Alexandria, correct?
Yes.
And the job you got was at Anoka State Hospital?
Yes.
That was between your Skills? Say that again.
So
slowly.
I got hired there in February, and I worked for a year on a calendar year. But the Anoka City Police Department would allow their students to, or their employees, to go to Skills and still have a job on weekends or when they would get back before they got hired as a law enforcement officer.
So at Anoka State Hospital, what did you do?
I was a security officer.
And Anoka State Hospital is basically a detox center now, is that right?
No, it had a detox. It had a countywide detox and a detox program. It also had drug and alcohol abuse rehabilitation and mental illness.
And what did you do there? You were in security?
Yes.
Does that mean you had to deal with the folks that are staying there, the residents?
Yes.
And were you successful in that?
Yes.
After working there, where did you go next?
I left there and got hired at the City of Brooklyn Center.
In what year were you hired at the Brooklyn Center Police Department?
1995.
And when were you sworn in?
February the 27th.
Of 1995?
Correct.
Who was that you're swearing?
My mother and my father.
So after you're sworn in, you started working as a Brooklyn Center police officer?
Yes.
And what year was that again?
1995.
So that would be, my math, 26 years before you resigned? Is
Yes.
that a fair statement?
Yes.
When you worked as a police officer at Brooklyn Center throughout those 26 years, did you remain a patrol officer all during that time?
I did.
And why was that? Why didn't you attempt to go up the ladder like the other officers we've heard from?
I liked my work. I enjoyed working with community. I didn't want to be in an administrative role.
But did you also, even though you were a patrol officer, you did take part in other programs, for example, the FTO program, right?
Yes, I did.
And that's the field training?
Yes, I was a field training officer for many years.
How many years?
I don't have an exact number, 10 to 15.
And we've learned in this case what a field training officer does, but very briefly, what did you do?
I would get probationers in different stages of their training, either in their first phase, their second phase, their third phase, or their final phase. Usually, the primary phase or the first phase and the final phase were always with the same FTO. And then other FTOs would train the other two stages.
And why did you continue to do that for so many years?
I felt that I had knowledge and mentorship that I could help young officers develop into somebody I would want to work with and my partners would want to work with.
There are other programs that you volunteered for or joined while
Yes.
you were a police officer, is that correct?
Yes.
And after you became a police officer, what was the first program that you joined or volunteered?
I became an Explorer advisor for our Explorer post.
And what's an Explorer post? Is that the younger people that are...
Yes, the program through the Boy Scouts of America.
And in that program, you teach them about policing, is that right?
Yes.
And after that Explorer program that you joined, what else did you do as a police officer?
I was on the domestic abuse response team. I was also a crisis negotiator.
Let's stop at the domestic abuse program. How long were you on that? Approximately.
10, 12 years, maybe more, maybe less.
And what did that program entail?
We would respond, so officers would go out on domestic abuse situations or domestic calls, and if there was a victim of a crime or an arrest made, or not an arrest made, we would follow up the next day with the victims to see that they were getting the things they needed, like domestic advocates, walking them through getting order for protections if they had questions, and then helping them and checking in with them through the court process.
And did you enjoy doing that?
Yes.
Why?
Sometimes there were great successes, and sometimes there were very sad failures.
There's another program that you're involved in, was a hostage program?
I was a crisis negotiator for the parent umbrella of the EOU team, the Emergency Operations Unit.
And what did you do in that?
I was a crisis negotiator.
What does that mean?
We would go out on barricaded subjects, or we would go out with the, I guess a SWAT team would be the easiest way to describe it, on warrants. We would respond to calls where there may be people in danger.
And was your job to try and negotiate with the subject and get him to submit to being arrested?
Yes, he or she.
Was that your main job?
No, I was always a patrol officer.
No, I mean, as far as a hostage negotiator, that's what you did.
Yes, I was a crisis negotiator.
And what other programs were you in?
I was on the Law Enforcement Memorial Association Honor Guard.
And what is that?
So the parent is the Minnesota Law Enforcement Memorial Association. They do a lot of work to help survivors and their families make their way through the process of getting benefits after their officer is killed in the line of duty. I was on the Honor Guard.
What did you do being on the Honor Guard?
When I started in 1998, I was on the colors team for approximately a year or two, and then I went to the casket team.
Well, what's the color team?
The color team carries flags.
And the casket team?
We would carry the casket or the urn of the fallen officer and then fold their flag.
And would you be in contact also with the victim or the deceased family?
Sometimes with the family, a lot of times with the chief of police, because I would have to have to give the folded flag to the police chief.
And this was throughout the state of Minnesota?
Yes.
And these were police officers killed in the line of duty?
Yes.
Or other law enforcement officers?
Most 99% of it would be killed in the line of duty, or we would do some retiree funerals.
Any other programs you're involved in?
I did a lot of crime prevention work for our police department and other presentations.
Crime prevention presentations?
Yes.
What were those?
I was assigned an apartment complex in the city, and I would meet with management, and we would do some programming for their residents as far as personal safety, locking your car doors, taking valuables out of your cars, just regular safety in an apartment complex. And then I would do some other presentations on robbery prevention for banks in the city.
By the way, when you were doing the carrying caskets for that in that program, were you aware of officers that were killed in the line of duty by making a traffic stop?
Yes, Sean Patrick from Mendota Heights.
Objection, Your Honor. Move to strike and echo.
The objection is overruled. I'll let the answer stand.
During your 26 years as a police officer, did you ever receive any complaints for abusing your power?
No.
Did you ever receive any complaints from the public?
No.
In training, did you attend all the training sessions required by the Brooklyn Center Police Department while you were there?
Yes.
And with respect to gun training, laser training, you attended all those too, right?
Yes, I did.
And did you pay attention?
Yes, I did.
With respect to that, in your approximation, I'm not asking for exact numbers, but with respect to the training, what would you say the amount of training was for the firearm, for the gun, and the amount of training for the laser? What would be the percentages there?
For the firearms, it would be probably 80%. We spent a lot more time on firearms than we did on taser.
And tasers didn't come into the being until years after you're a law enforcement officer, right?
Yes, I believe trainers in this courtroom had said 2002 or 2003.
And you started as a law enforcement officer, what year?
1995.
With respect to tasers, I say lasers, respect to tasers, there's been evidence in the case that you had a Taser 7, is that correct?
Yes.
And the evidence in that was that the Taser 7 was shaped like a gun, fair statement?
Yes.
And the Taser 7 had a dark black, or at least a dark handle, and a dark top. Do you remember that?
Objection. Leaving.
I'm trying.
The objection is overruled. You may answer.
Yes.
The Taser that you received, was it approximately a month before April 11th that you received this Taser? Do you remember?
In the courtroom, I was told I received it on March the 26th.
Okay. And also, while we're there, with respect to these tasers and testing them, the rule that we read said should test the electronics every day. Is that right?
Yes.
And there is testimony that you didn't test yours a couple days. Is that right?
Yes, that's what I was told.
And do you agree with that you didn't test it?
I don't recall if I would have or wouldn't have.
And was that an important feature for law enforcement officers with new tasers
No.
that never used them since they had them?
Correct.
And while we're there, did you ever use a taser, use it by actually shooting it in all your years' career as a law enforcement officer?
I would take my taser out on rare occasions, but I don't believe I ever deployed it.
Okay, when you take your taser out, it's to de-escalate what is going on. Is that a fair statement?
Sometimes, or to prepare for what might be behind a door. Sometimes an officer has a gun and sometimes an officer has a taser out.
All right. And now the taser that was switched from you, did that go to one of your partners, that taser?
My old taser?
Yes.
I believe they were just put in storage at the police department.
And those tasers were all yellow, right? The handle, the top, the whole thing was yellow.
Yes, except for the battery pack. I believe that was black and there was some
Okay.
markings on the side.
I'm going to show you these tasers. show you this taser.
Objection, Your Honor. May we have a sidebar, please?
Yes. All right, the objection is sustained.
Okay, well, do you specifically remember your old taser? By that I mean the one before the 7 being all yellow.
Yes.
And was that an X26 taser?
I believe it was an X26P.
P? So, with respect to the tasers, there's been evidence about signing some forms on warnings. Do you remember signing those forms?
In our annual training, we would be handed a form to sign, and I would sign it.
And do you remember the warnings on them at all?
Not from those days, no.
And with respect to weapons confusion, was there ever any training, actual training about weapons confusion as you remember it?
No.
Did you even know what weapons confusion was before?
Yeah.
Wait till I finish the question. Before April 11th?
It would be mentioned in training, but it wasn't something we physically trained on.
And by that you mean what?
There was no training on weapons confusion. You wouldn't be set in a dark room and told to grab which weapon.
So I'm going to go now to April 11th, 2021, a Sunday. And you surely remember that day. Is that correct?
Yes.
And you were in FTO that day for Officer Lucky?
Yes, I was.
And that day, what time did you go on duty?
6 a.m.
And was Lucky on duty at that time too?
Yes.
And about, what did you do during the morning? If you remember, did you just do drive around police work?
We just did police work. We would have checked a squad car if we wouldn't have had calls right away.
It was a Sunday.
It was a Sunday.
So approximately around 2 o'clock, did you pull up in back of, or not you, Officer Lucky was driving the car, right, the squad?
Yes.
And you were the FTO. Where were you seated in the car?
In the passenger seat.
And tell the jury what you remember about first seeing the white Buick on that day, approximately 2 p.m. And talk slowly.
Officer Lucky and I were driving south on Zane Avenue North. We were talking about pursuit policies, doing some regular FTO training, and he observed a vehicle in the turn lane with a blinker on inappropriately.
And was that the white Buick?
Yes.
And did you have a conversation with him about that?
Yes.
And what was that conversation?
We discussed a little bit of suspicious activity. He noticed a pine tree or air freshener hanging from the rearview mirror, and the tabs were expired.
And did you stop that vehicle?
Officer Lucky wanted to stop the vehicle, yes.
And let me ask you sort of a hypothetical. If you had been working alone that day on Sunday afternoon at 2 o'clock, would you have stopped the vehicle for...
Objection, relevance calls for speculation.
I can't even finish the question, Your Honor.
All right.
That's not fair. It's simply, they know how to try a lawsuit, I would think.
The objection is overruled. You may answer.
My question was, if you weren't with a field training officer that day and you were on patrol alone, would you have stopped that vehicle?
Most likely not.
And why not?
An air freshener to me is it's just an equipment violation. And during the COVID times, the high COVID times, the Department of Motor Vehicles was so offline that people weren't getting tabs, and we were advised not to try to enforce a lot of those things because the tabs were just not in circulation.
Okay, but You did stop the vehicle, right?
Yes, part of field training is that my probationer would make numerous contacts with the public throughout the day.
And what happened after the stop? Or if you remember, go ahead.
Before Officer Lucky stopped the car, he ran the vehicle, confirmed that the registration was expired, and that the registered owner had a petty misdemeanor type warrant for some type of drug offense.
And that was the registered owner of the vehicle?
Yes.
So after you did that while you were still in the squad car and not?
Yes, it's part of the multitasking that a probationer will have to do, is run a vehicle license plate, call into dispatch, and initiate their lights.
Okay, and try and talk a little slower. I know you're probably nervous, but I'd like to get all this in. All right?
Yes, sir.
Okay, so you stopped the vehicle, is that right?
Officer Lucky initiates the traffic stop.
And what happened after he did that?
The vehicle stopped kind of in an entrance to the church on 63rd, and he got on the PA and told the vehicle to pull ahead just a short distance.
Was that because he was parked in the driveway of the?
Yeah, and I think there was a vehicle trying to come out, as I recall.
Okay. What happened next?
Officer Lucky and I exited our marked squad car. Officer Lucky walked up to the driver's door, and I stood at the right rear corner of the white Buick.
So you did get out of the car?
Most definitely.
And why did you stand where you were standing?
Part of it was so I could see where Officer Lucky was, and to provide cover to see what else was in the vehicle.
In your experience of 26 years and being a patrol officer all those years, is stopping any vehicle at any time that you don't know, does that be considered a dangerous situation?
Yes.
Why?
Sometimes there's guns in the car, sometimes there's uncooperative people. You don't know who you're stopping.
Yeah, because you don't know, right?
Right.
So while you were standing there in the rear of the vehicle, did you hear what Officer Lucky said?
I could hear parts of the conversation. He didn't seem to be in any distress when he was asking questions. He took out his notepad, and it looked like he was writing down something which would end up being a name and a date of birth.
Okay, and after he did that, did you two go back to the squad car?
Yes.
And at some point in time during the stop or right after it, did Officer Lucky do anything in connection with obtaining another squad car?
Yes, he called for a second car to come.
What is that about? What?
It would just be a backup officer. The registered owner had a warrant of some nature. It wasn't a bad warrant. It was just a regular petty warrant, which would still, you'd want a second officer. Or I guess in this case, a third officer. Officer Lucky and I are considered only one officer.
And why are you and Lucky just one officer?
Because he's in field training and he's a probationary employee.
All right. So did the third officer, Officer Johnson, arrive at some point in time?
Yes, Sergeant Johnson arrived.
And was that before you looked up in the computer about this driver of the vehicle, or after?
I don't know exactly when he arrived. I know Officer Lucky and I were Officer Lucky and I were discussing running the name he was given through some various systems.
Okay, and did you do that, you and Officer Lucky?
Yes.
Was there any correction that you told him about during this time that he shouldn't have put the name in one?
He had gone to the Minnesota, because the driver didn't provide him with any government-issued ID. He would have had to verify some information to run him properly in our system through TriTech. So you run them sometimes through Minnesota DVS with just a name and a date of birth. It'll give you a Soundex hit on various people with that either same name or common name with a date of birth.
So did you correct him on that?
We were talking about, I don't know if I corrected him on it, but
So what happened after that?
he would copy the OLN, which is a driver's license number, off the screen and then put it into our TriTech system, or CAD, and that would run him through the state for driver's license and warrants and other hits.
And did you find anything about the driver?
The driver came back with a suspended driver's license, a gross misdemeanor, bench warrant for weapons, and a protection order.
So, a gross misdemeanor for weapons ordinance. What went through your mind, if anything, when you read that?
It would be concerning that there'd be a weapon on the person or in the vehicle.
And why would that be?
In my experience over 26 years, I have found guns in cars, either by accident or by them just being sitting out in plain view.
And what about a person with a weapons warrant?
They're more likely to be carrying a weapon or have a weapon access to them.
So, what about the temporary, was it a temporary restraining order that came up? Was that it? Or?
Yeah, I think they're called ex parte orders. It would be a temporary protection order until the parties would either have a court hearing in front of a judge to make it a permanent order.
And there would be a name of a female on that?
Yes,
order?
there was.
And was there a female in the Buick or in the automobile that was stopped?
Yeah, in the front. Yes, in the front passenger seat.
So after you learned that, did you also learn something? Did Officer Lucky tell you something about drugs or marijuana?
When he initially got back to the car, he told me there was a obvious smell of marijuana and some seedlings or shake residue on the center console and inside the vehicle.
Okay. So with all of that information, what did you do next?
Officer Lucky explained to Sergeant Johnson what was going on.
Where was Sergeant Johnson? Was he in your squad car?
He was standing at my passenger door.
Go ahead.
And Officer Lucky was explaining to Sergeant Johnson what was happening and what he wanted to do. Officer Lucky only told Sergeant Johnson that he had a warrant, and I told Officer Lucky that he needed to tell Sergeant Johnson what the warrant was for. A weapons violation warrant would be cause for care and concern.
All right. And after that conversation, what happened, if anything, next?
We got out of the vehicle. Sergeant Johnson was going to the passenger side. And
Excuse me, don't mean to interrupt you. Back up a little, I'm getting ahead of me. What was the plan when you got out of your vehicle with Lucky and Johnson was outside? What was your plan?
The plan was for Officer Lucky to get the driver into custody for the warrant, and we'd further investigate with the female who she was and if she was the petitioner or the subject of the restraining order.
Were you required by policy and law in learning about that warrant to arrest the driver of that car?
Yes, it was an order of the court.
And with respect to the restraining order, or whatever you called it, did proper police procedure that you knew of for 26 years required to find out who that lady was?
Yes.
And why would that be?
It's my duty to find out who she is to make sure she's not in harm's way. There's been times when that hasn't happened and somebody has ended up killed because that wasn't followed.
So now we're at the Buick. It's a Buick car, white car.
It's a white car.
And now we're at the white car, and you three went up to it, correct?
Yes, Sergeant Johnson went up to the passenger side. He went up the passenger side to provide cover.
And what does provide cover mean?
Keep an eye on the occupants of the vehicle and just to monitor what's happening outside in the world. See if people are walking up on you or things go wrong.
And where were you located?
I was towards the left rear corner of the car.
And where was Officer Lucky?
He was advancing to the driver's door.
And how, by the way, before this, how long had you known Officer Lucky?
I think we were on our 5th shift.
And he was pretty new arrival, was he? Or?
I believe he was in second phase maybe, but he had been a police officer before.
Okay, what does second phase mean?
He wasn't in his initial 4 weeks, he was in the start of his second 4 weeks.
And you testified you knew, at least back then, that he had come from another police department, correct?
Yes, I think he worked at 2 previous agencies and he was an explorer.
Okay. Now let's go back to when you three arrived at the white car. We've already said where you're located. Officer Lucky was at the driver's door, is that right?
Yes, he would have been standing behind the post between the driver's door and the rear passenger door.
What do you mean by that, standing behind the post?
He wouldn't have been directly in front of the door because that would be unsafe approach.
And this was this a warm day? Was the window down? Remember?
I don't know if the window was down or not.
Okay. But in any event, where were you standing again?
At the left rear corner.
And did you hear what Officer Lucky said?
Yes, I heard him ask the driver to step out of the vehicle a couple of times.
And did the driver step out of the vehicle finally?
Finally, he asked Officer Lucky a couple of times what was going on, and Officer Lucky said he would explain to him.
When he got out of the car?
Yes.
And so did the driver get out of the car?
Yes.
And what do you remember happening next?
Officer Lucky had him turn around, and I think he was still asking what was going on. Sergeant John.
Who's he?
The driver.
Go ahead.
And Sergeant Johnson and Lucky told him he was under arrest, and I told him he had a warrant.
Okay, so who said he was under arrest first?
Sergeant Johnson, I believe.
And Sergeant Johnson testified here. You remember that?
Yes.
And after he said that, did Officer Lucky say he was under arrest too?
Yes.
And you heard that?
Yes.
And what did you say then?
Good afternoon, everyone. Tim Blotz in the Fox 9 newsroom. We are breaking into our programming here on Fox 9 and continuing our special coverage on fox9.com and the YouTube channel in the manslaughter trial of Kim Potter. She has taken the stand in her own defense today. We are just coming back from lunch break. She is now back on the stand and will go under continued cross-examination from Assistant Attorney General Aaron Eldridge. Let's take you now back into the courtroom. Here's Judge Regina Chu.
Something, Mr. Frank? Oh, you're just standing up. Okay. All right. Are we ready for the jury?
We did work on some proposed language for that jig.
Oh, yes. Okay. I had my law clerk send you a copy of a new draft. Okay. Well, we can talk about jury instructions after we get the testimony in. Okay? All right, thank you, Deputy. Okay, please be seated. All right, counsel, you may continue.
Thank you, Your Honor. Ms. Potter, before we left for the break, we were walking through what happened on April 11th. You'd agree that for a large part of the interaction at the side of the car with Mr. Wright, you were standing behind Officer Lucky, right?
I was next to him at some point.
Okay. And you testified on direct that after you saw a scared look in Sergeant Johnson's face, that's why you decided to use the taser? That was your testimony?
Yes.
But you also told Dr. Miller that you don't know why you decided to use the taser, right?
I haven't seen his report.
Would it refresh your recollection to see his report?
Yes, please.
May I approach your honor?
You may.
Did you have a chance to look at that, Ms. Potter?
Yes.
And did you see the portion where it explains, when asked by this examiner why she decided to draw her taser, Officer Potter states, "I don't have an answer. My brain said grab the taser." Do you recall that?
I don't recall it, but it's in his paperwork.
So on April 11th, you reached down and drew your weapon, right?
Yes.
And you said taser, 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 so Officer Lucky and Sergeant Johnson would disengage, right?
Yes.
And they did disengage, didn't they? They let go of Daunte Wright and stepped back?
According to the video.
And after you shot Daunte Wright, shot him, I'm going to go to prison, and I killed a boy. You said all those things, right?
I don't remember.
If that's what's in the video, that's what you said, right?
Yes.
And you said that there are a lot of things that you don't remember, and that on direct you testified that your memory came back when you saw your husband that day. But didn't you tell Dr. Miller that you remember seeing the gun in your right hand? You said that, right?
I don't remember. My interview with him, I was distraught. I wasn't in a good place.
After you shot Daunte Wright, you didn't behave like someone who had just saved Sergeant Johnson's life, did you?
I was very distraught. I just shot somebody. I've never done that.
Well, you never asked Sergeant Johnson if he was okay, right?
I don't remember the conversations.
You didn't check in on him at all, right?
I don't know.
Well, you saw the video when Sergeant Johnson fed you the line, "That guy was trying to take off with me." You didn't bite, right? You didn't respond to that at all, did you?
The video, I was crying. I was in shock.
And he was trying to make you feel better, wasn't he?
Back to that foundation. Is
The objection is sustained.
Well, he didn't remember saying it, right? You heard that testimony?
Yes.
And you don't remember him saying that, right?
No.
And you didn't say anything like, "Thank God I shot that guy and saved your life." You didn't say anything like that, right?
back to that as argumentative.
The objection is overruled.
You didn't say that, right?
No.
And you didn't ask Sergeant Johnson anything except to call Chuck, right?
I don't remember what I asked him.
That would be on the video, right?
Yes.
You'd agree that as a police officer, you have the duty to render aid and communicate information to other officers, right?
Yes.
And it's part of your job to assist those who are hurt or injured. True?
Yes.
And to communicate to other officers what you know about a particular scene, right?
Yes.
Give them whatever information you can to help them do their jobs, to help render assistance, things like that, right?
Yes.
But you didn't do any of those things on April 11th, did you?
No.
You stopped doing your job completely. You didn't communicate what happened over the radio, right?
No.
You didn't make sure any officers knew what you had just done, right?
No.
You didn't run down the street and try to save Daunte Wright's life, did you?
No.
You didn't check on the other car that had been hit, did you?
No.
That all happened just down the road from you.
Yes.
You were focused on what you had done, because you had just killed somebody.
I'm sorry it happened. I'm so sorry.
Ms. Potter, from your reaction today, and from your reaction on your video, you didn't plan to use deadly force that day, did you?
No.
You didn't want to use deadly force, did you?
That's irrelevant. If she planned it or wanted it, it's a constructive fact.
The objection is overruled.
You didn't.
No.
Because you knew that deadly force was unreasonable and unwarranted in those circumstances.
I didn't want to hurt anybody.
You didn't want to hurt anybody. And you didn't want to kill anybody.
No.
And that's why you said, I'm going to go to prison.
I don't.
That's 3 times now, Your Honor. Repetition.
All right. The objection is sustained.
Ms. Potter, you know the difference between left and right, don't you?
That's objective now. She's asked that before. It's argumentative.
It's not been asked, Your
The
Honor.
objection is sustained. It's argumentative.
Nothing further, Your Honor.
Ms. Potter, do you need a break?
No.
Okay.
Yeah, Johnson, lucky. Just going to ask you a few questions. Do you remember your visit by Zoom with Dr. Miller? A little bit at least.
We had a Zoom interview, yes.
Okay, and that was Miller in Florida, correct, as far as we know?
Yes.
And you and me were in my office, correct?
Yes.
And that was the first time that you had ever seen any of the video, correct?
Yes.
And were you able to watch it?
No.
And you did tell Mr. Miller that when Wright pulled away and got back into the driver's seat of the car, which was still running, Potter, that you could observe Johnson and Lucky struggling over the console, and it appeared that Johnson was trying to prevent Wright from putting the car in drive.
Objection leading.
The objection is overruled.
If you don't remember that, because it was a while ago, I can show it to you to refresh your memory.
I don't remember.
May I approach, Your Honor?
You may.
Read to yourself, Ms. Potter, the last sentence of the second to the last paragraph. Does that refresh your memory? as to what you told him?
Yes.
And did you tell him that? Pardon me, I didn't hear you.
If it's in there, I must have. That day is so blurry.
Did you also tell him that you yelled taser, 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 so your partners would disengage from Wright?
Yes.
And just a few more questions here. Would it be routine, thinking back when you're a law enforcement officer for 26 years, would it be routine for you to unsnap your holster on the way to a car?
No.
And why not?
I'm only 5'3". If I would get into a fight, I could lose my gun.
Did you ever, in your career, shoot your gun at anybody?
No.
Did you ever shoot your gun in real life during your career?
No.
And did you ever shoot your taser during your career?
It was never deployed.
Is that what it means?
Yes.
And that would be real life. That would be when you have to use those weapons. That would mean it was an emergency situation, would it not? Well, what would it mean to you? Yeah, sorry. Thank you, Judge. What would that mean to you if you had to shoot your weapon?
That I might kill somebody.
When you three law enforcement officers, and excuse me, by the way, as far as reporting this shooting, would it be Sergeant Johnson, your boss, would be the one that would be required to do that?
Objection leading.
Well, rephrase it.
that. Who would be required, according to policy, to report the shooting? Would it be the shooter or the other person who was in charge there?
On that scene, it would have been Sergeant Johnson.
Because he was your supervisor, correct?
Yes.
Then I got a couple more questions. If you stopped a vehicle in Brooklyn Center and you learned that there was a bench warrant for a weapons violation, you learned that there was a temporary restraining order a female had lodged against the person that said he was in the car, that gave his identity. But he really did Mr. Wright ever give a valid identification for himself?
No.
And the other office, now you've got no valid information, you've got a gross misdemeanor, you got a temporary restraining order, you got marijuana smelled by your partner, you got no license, no insurance. Would you let that car go if you went up to it and were attempting to handcuff the individual and the car, he jumped back in? Would you have thought you should let him go, drive down the street?
No.
On the temporary restraining order, if you learn there is a temporary restraining order, is it protocol? Is it policy to, as soon as you learn that, jump out of the passenger side, run up to the car and ask the lady what her name was? Has that ever been heard of in police practice that you know of?
No.
Thank you, ma'am. That's all I have, Judge.
Is there any recross?
Yes, Your Honor.
Yes.
Ms. Potter, you were asked about some statements that you made to Dr. Miller on redirect, right?
Yes.
You also told Dr. Miller that you resigned on April 12th to protect your police family, right?
Judge, I object to this improper re-cross-examination. I never got into that. I just got
Okay,
into one statement.
Your Honor, the statements to Dr.
Yes.
Miller are at issue.
I'm going to overrule the objection. You may answer that.
You told him that, right?
Can you repeat the question?
You told Dr. Miller that you resigned on April 12th to protect your police family, right?
If it's in the report, yes. I haven't seen the report except today.
Well, if it's in the report that you also said that they're very important people to you, would that be accurate?
Yes.
You have a very close relationship with the police officers, other individuals you work with or used to work with at Brooklyn Center, right?
Some of them.
Sergeant Johnson is a good friend of yours.
Judge, I object to this and outside the scope.
The objection is sustained beyond the scope.
You also told Dr. Miller that you don't make mistakes, right? You told him that?
If it's in the report, yes.
And you told him that you don't want to hurt or injure anybody. Right?
Right?
But you mentioned to Dr. Miller your relationship with the individuals that you work with, right?
Yes.
And that was very important to you, right?
Yes.
You advocated for their interests in a lot of settings, didn't you, for the people that you worked with?
I advocate for everybody.
You had a very close relationship with them. You referred to Sergeant Johnson as a rock star, haven't you?
I don't know when I would have done that.
Nothing further, Your Honor.
Go ahead, Mr. Gray.
In all of your years there as experience in all of the patrols that you conducted, did you have to rely on your partners for assistance anytime you did a stop or an investigation of any nature?
Yes.
And that would be the family of the police department at Brooklyn Center, correct?
Yes.
And they were your second family, weren't they?
Yes.
As far as complaints, in the 26 years that you were a police officer, did you ever have one citizen complaint?
Objection, Your Honor, outside the scope.
The objection is sustained beyond the scope.
I have no further questions.
Any further cross?
No, Your Honor.
All right. You may step down.
Thank you.
Thanks, Russ.
To our viewers on Fox 9, hello, this is Tim Blotz in the Fox 9 newsroom. You've just been watching emotional testimony of Kim Potter on the stand under cross-examination here this afternoon in her own defense in the manslaughter trial for the death of Daunte Wright in a traffic stop that occurred on April 11th of this year. This trial is now one step closer to wrapping up and heading to the jury. We expect that Mrs. Potter was going to be the last witness to testify in this trial. We are going to now return to regular programming on Fox 9. We will have coverage tonight on Fox 9 News beginning at 5 o'clock with my colleague Paul Bloom. If you want to watch our continuing streaming coverage from the courtroom, you can do that on fox9.com and on our YouTube channel. In the meantime, this is Tim Blotz on behalf of Fox 9. We now return you to our regular programming.
I've got to read the cautionary long version again. so that you don't do any research. Don't let outsiders influence you. This includes family members and friends and anyone else who is not actually involved in this trial. Don't discuss the case with other jury members during the trial. Again, you'll have plenty of time to do this at the end of the trial. Once you have had all the evidence, I've sent you to the jury room with my instructions and the verdict forms. Don't talk to anyone involved in the case, of course, the defendant, the lawyers, or the witnesses. If anyone tries to discuss this case with you outside the courtroom, please report this to me. When you go home over the weekend, do not talk to your family, friends, or others about the case. You may tell them that you are a juror on a criminal case, and that is all that you should tell them. Do not report your experiences as a juror while the trial and deliberations are going on. Do not email, blog, tweet, text, or post anything to Twitter, Facebook, LinkedIn, Google, YouTube, or other social networking sites about this trial, even if I have not specifically mentioned other social media sites. Don't visit any chat rooms where this case may be discussed. Do not read or listen to news reports on newspapers, magazine, radio, television, podcasts, or other media about this case. Don't do your own investigation. Do not ask people about the case. Do not visit any of the locations mentioned in the trial. Do not use internet map applications such as MapQuest or Google Earth or similar mapping media to view the locations. Do not research anything about the case, including the issues, evidence, parties, witnesses, location, or the law through any form of written, print, electronic, or internet media, including Google, Safari, Firefox, Bing, or other similar search engine. Do not create your own demonstrations or reenactments of the events which are the subject of the case. Remember, you can't consider anything you hear or learn about this case outside this courtroom. If you don't follow these instructions, again, you may jeopardize the trial and we might have to start all over again. If you become aware that another juror may have violated any of these rules, you need to let me know that. Okay? So, members of the jury, first of all, I want to thank you for your attention during this trial. I want you to have a good weekend, and we'll reconvene on Monday at 9 o'clock. Great, please be seated. Okay, counsel. Okay. All right. All right. Okay, you should have received another draft of the jury instructions by email. I had Zach do this, or Mr. Kramer do this in 14 points, so us older folks can read it. Okay. So, have you had a chance to review the new draft?
No.
Okay, I'd like to have a discussion about jury instructions this afternoon. Why don't we take a half an hour break? And Mr. Frank, if you could send me your suggested language on the non-deadly force. I've got one in here, a clarifying provision in it, but I'd like to see yours. So a half an hour should be enough? Okay. Okay, we'll reconvene at 2:30.
Can Ms. Potter be excused?
Yes, you may be excused. I mean, she's coming back for jury instruction argument, right?
Oh, yes.
Okay. So, 2:30.
Tim Blotz here in the Fox 9 newsroom. Welcome back to our continuing streaming live coverage here on fox9.com and the YouTube channel of the manslaughter trial of Kim Potter for the shooting death of Daunte Wright in that traffic stop on April 11th earlier this year. Kim Potter now finishing up her testimony. The judge going to return here in another half hour to talk about jury instructions, as this case is clearly over now and heading towards the hands of the jury. Let me bring in my colleague Paul Bloom, who's been reporting on this since the very beginning. Paul, we knew this was going to be emotional today. It was that and then some, but I think clearly both sides perhaps got something out of her testimony.
I think you're right. It was intense. Kimberly Potter, let's be honest, just went through one hell of an experience, retelling that story, reliving it. I saw a physical reaction right before lunch, watching the body camera footage back as she's yelling, "Taser, taser, taser." She kind of shook, almost awake. It was kind of disturbing to see that, the emotion. I thought it was an effective cross by Aaron Eldridge, kind of going right up to that line where you don't want to maybe push, the defendant into a state where all of a sudden the jury is sort of sympathetic that you're, going too far. How it plays, I just don't know. I mean, my gut is we come back to the facts now of the case, which is basically it was a mistake. Clearly, she did not intend to kill Daunte Wright that day. She admitted it several times there during her testimony. But should she have known better? And is that mistake criminal? Well, let me tell you, next week, a jury of 12 fellow citizens from Hennepin County will start deciding whether or not it is. The state thinks it is. The state thinks it's manslaughter. She should have known better, heavily trained, years of experience, all the training you would need to get it right in the heat of that moment. And then obviously in the heat of the moment, getting it wrong. Is it criminal? We'll see next week. Closing arguments to come on Monday. Jury instructions, vitally important, Tim. I know it'll probably not be, exciting to watch the live stream, but certain wording, certain instructions that are included here will be critical, because this jury, once they get into their deliberation room, are going to go line by line. Definition of manslaughter 1, definition of manslaughter 2, culpable negligence. How is recklessness defined? What about justifiable use of force? So as they go down this list, they will have to make those decisions, and we'll have a verdict, and this community will have spoken on that April 11th deadly traffic stop in Brooklyn Center.
Paul, you talk about the jury instructions coming up here in just about 29 minutes from now when they get underway again. Judge Chu made it very clear last night that she was going to add a jury instruction on authorized use of force. And she just handed out the new packet of the proposed jury instructions to the attorneys to review. They're going to talk about that here in the next half hour. And that plays right into the defense's now second prong approach in this case, that given the fact that she mistakenly drew her handgun, she could have been authorized to use that gun and deadly force because the lives of other officers were in danger, particularly Sergeant Johnson, who was in the car trying to disengage it to prevent Daunte Wright from moving that car. And in her testimony this morning on the stand, she testified he had the look of fear in his face. It's something I had never seen before, and she started crying. She said, "I was trying to keep him from driving away. It went chaotic. I remember yelling, 'Taser, taser, taser,' and then something happened, and he told me I had shot him." And she broke down on the stand again. Very emotional towards her, but she clearly had fear in her mind. Whether the jury now decides that that was justified in her use of a handgun or not, only they can tell.
And Tim, I would just point out she verbalized fear on the witness stand, but the state came back with texts, quotes from Dr. Miller's interview, where that wasn't spoken about, and in the moment, there was no verbalizing that I saved your life. Thank God I shot him, but you're alive. There was none of that reaction. So she verbalized it on the witness stand. How the jury processes it vis-a-vis the rest of the evidence in the case file, we shall see. But you are right. She did testify that I look over and I've never seen the fear in the face as I did in Sergeant Johnson. I had to do something, and then all of a sudden, she pulls out the weapon and fires the one time. Is it the gun? Is it the taser? Whatever it was, she needed to protect him. She's saying that now. I'm not necessarily clear if all of the evidence supports that through this whole process. But we will see. Again, the jury will need to process it. Again, the jury instruction's huge, and then we'll go forward from here. But it was quite emotional. The only other thing I would say too is the blanks around some of that moment. And I know, again, I'm a news reporter. I don't do this for a living in terms of policing, and I have no idea the human experience that Kim Potter lived through. In that moment, I just noticed that there are I don't remember a lot of blanks around there that we just truly we didn't get a total full picture of that scene moment by moment. I just want to point that out again. I have no idea what it's like.
Well,
my heart goes out to everyone involved here, but I would just say there are a lot of blanks kind of right around that moment of pulling the trigger.
I think she clearly left the jury with the impression that she's been traumatized by this.
Oh, sure.
And there's no question that two families here have been traumatized by this. Daunte Wright's family, who are suffering this loss, and Kim Potter and her own family, who are suffering with what Kim is obviously going through in the aftermath of all of this. Paul, I would say that I thought under cross-examination by Assistant Attorney General Erin Eldridge, I thought she was rather effective in getting at the main prosecution points here that she should have known better. And under cross-examination, Erin said, quote, "You agreed that you were bound to policies at the Brooklyn Park Police Department." And Kim Potter said yes. Erin continued, quote, "You agreed that your fundamental responsibility is to safeguard life, right?" Kim Potter said yes. And I imagine that in closing arguments here, closing statements, Erin may very well, or Matthew Frank may use that against her to try and seal in the minds of the jury that she should have known better and violated her training.
And again, the question it boils down to is this manslaughter. I just think you could totally believe Kim Potter, everything she said, everything she saw that day. We can all agree she wanted to pull the taser. She didn't. I don't know. I don't want to say most people would agree Daunte Wright shouldn't be dead. And here we are. And this is, 8 months removed from this situation. I remember, Tim, I took a call in the immediate aftermath of this from a source close to kind of the police side of this. And they kind of wanted me, the things were starting to fester in Brooklyn Center. Anger was starting to build in the streets. I took a call from a source who would know. And they told me that it was accidental discharge. You need to get it out. She meant to pull her taser. And this source thought that would calm everything down. The problem would be resolved. Obviously, Brooklyn Center Police Chief at the time, Tim Gannon, would release the body camera footage the next day, showing it was an accident. And in some people's mind, it was an accident. It shouldn't have happened. Daunte tried to flee. It did. We should move on. Clearly, the state feels otherwise. They feel that after 26 years on the force, of all the training, she should have been ready for that moment. And they see it as a criminal mistake, that she needs to be held responsible for killing Daunte Wright in that moment. I just can't say enough that this jury of 12 will make the decision. They will have the final say on this. We can parse around the edges of the legalities of it. There's the human emotion here. These are people who will make the decision, just as Kimberly Potter was human police. We're fallible. We'll see what a jury does with this case.
And we know this is such an emotionally, politically, and socially charged issue. I mean, this case led to nights of unrest in Brooklyn Center, happening in the middle of the trial, and everything going on here with George Floyd as well. And ultimately, it doesn't matter what anyone else thinks other than those 12 jurors who will now decide this, perhaps coming up on Monday. All right, I'm looking at the clock here now. We are probably about 20 minutes away from the judge coming back into the chambers, where she and the other attorneys will start talking about the jury instructions that they will read to the jury after closing statements coming up on Monday, we presume now. In the meantime, in the next 20 minutes, we want to take you back to the cross-examination of Kim Potter on the stand that was taking place right before the lunch break. So let's take you back to that moment in time and Kim Potter back on the stand.
All right, so April 11th started as a slow and uneventful day, right?
I guess it's a Sunday.
Okay. I'm going to put on the screen exhibits 224 and exhibit 178 next to each other, please. All right, Ms. Potter, on the screen are exhibits 224 and 178. You'd agree that these are photos of your taser and your firearm, respectively, yes?
My firearm for sure. I'm not sure if that's the taser that was taken that day, but I'm guessing it is.
And you carried a taser 7 that day, correct?
Yes.
And that's what's in this picture, exhibit 224?
Yes.
Now these items look different, don't they?
Yes.
Your Honor's argument is
The objection is overruled. I think you answered. Did you answer? You may answer if you didn't.
Yes.
And just to be more specific, the taser is yellow, right?
Yes.
The firearm is black, correct?
Yes.
The taser weighs about half as much as your loaded Glock, right?
I don't know.
Doesn't weigh the same, correct?
That's what they testified to earlier, but I don't know.
When it comes to the taser 7 that you had just been recertified on or certified to use, your department used long-range cartridges for that taser 7, correct?
I don't know.
You were trained to use it, correct?
I don't know now. I don't remember.
You don't remember being trained to use the taser 7 at all?
No, I remember being trained, but I don't remember today what cartridges we were issued.
Okay. So you went out on the street with a taser, not knowing what that taser did?
I would assume that on the day I worked I would know, but I don't know. It's been months now.
Okay. No reason to dispute that the Brooklyn Center Police Department used long-range cartridges in the taser 7, correct?
No.
And the reason to do that would be so that you could fire at a farther distance with your taser, and you wouldn't need to approach someone up close, correct?
I don't know. I would assume so, but I'm not positive.
Well, that's why someone would use a long-range cartridge as opposed to a short-range cartridge, correct?
Yes.
Okay. And you've been trained on tasers since 2002, correct?
Yes.
You know how they work, right?
Mhm.
And you know
Yes.
what they do. Could we take those down, please, and put up Exhibit 214? Okay, Exhibit 214 that's been admitted is on the screen. Is this a picture of your duty belt?
Yes.
You'd agree that the holsters for your taser and your firearm are different, correct?
Yes.
And your firearm holster is empty in this picture, right? There's no firearm in it.
Correct.
Is that this right here?
Yes.
The taser holster is made of plastic, right?
Yes.
You have to push a button, this button right here, and rock it back to get it out of the holster, correct?
Yes.
And your gun holster is made of leather, is that right?
Yes.
And it has a little snap. Is that right?
Yeah. Yes.
And how does that gun come out of that holster?
It would rock forward.
How do you pull it with your hand out of your holster?
It would rock forward and you would pull it up.
Okay. And the taser, on the other hand, you would press the button, rock it backward, and pull it up, correct?
Yes.
All right, if we could take that down, thank you. Now, you testified that you have never deployed your taser or your firearm while on duty out on the street, correct?
Not that I recall. I know for sure my firearm.
Okay. But you have drawn your taser multiple times while on duty, correct?
Several times.
And you said that you did that as a way to de-escalate. I believe that was your testimony on direct.
Yes.
And approximately how many times did you pull your taser but not deploy it while on duty?
For de-escalation, maybe a few times.
Now, there are a couple times that you pulled your taser and didn't deploy it. One was in 2013, correct? No reason to dispute that it happened once in 2013, at least?
I would guess no reason.
There was a situation where one of your colleagues, a former officer, was hanging on the back of an individual, and you pointed the taser at him but didn't tase him because you would have tased your fellow officer. Is that right?
If it's the one I'm thinking, yes.
And instead of
She was on his back.
deploying your taser, you called for extra help, correct?
Yes, and we probably continued to fight with him.
You never deployed your taser then.
No.
And there was another incident in 2016 where someone was not complying with commands to place them under arrest, right?
I don't know what event you're talking about.
Well, in this case, there was an individual who was struggling, a female individual. She didn't want to get in handcuffs, and then one of the officers took her down to the ground by force, correct? And you pointed your taser but didn't deploy it, right?
If that's what the documents say. I don't recall the incident.
Okay. But you recall that you have drawn your taser and not fired it in your 26-year career.
Yes.
All right, I'd like to talk a little bit more about April 11th. So, on April 11th, you were serving as an FTO, right?
Yes.
And you said that you have done that for 10 or 15 years.
For many years. I don't remember when I got certified, but it's been many, many years.
Okay. And you said that on direct, I believe your testimony was that you had knowledge to impart and that mentorship skills that made you suited for that job, right?
Yes.
So you were serving as Officer Lucky's FTO on April 11th. How long had you been his FTO?
I believe it would be 5 shifts. It would have started the Monday after Easter Sunday.
Okay. But you were essentially in a supervisory position, right? Serving as his FTO?
Yes, I guided him.
It's a big responsibility, true?
Yes.
You have to be a good example, sort of set the stage for what a good police officer should do in any particular situation, right?
Yes.
And to do the job of an FTO, you have to be really familiar with policy and training and proper uses of force, right?
Yes.
And you have to make sure that someone else is doing it all right too, right?
Correct.
And you testified that that morning, the morning of April 11th, you reviewed pursuit policy with Officer Lucky, correct?
That afternoon.
Okay. But that pursuit policy includes not shooting at the driver or occupants of a vehicle, right?
A moving vehicle.
And you told Officer Lucky, we're not in the city, right? Did you tell Dr. Miller that you told Officer Lucky in reviewing pursuit policy, you use the phrase, "we're not in the city"?
Because we're on Zane Avenue, which is in Brooklyn Park.
And why did you say that?
To remind him of geographical boundaries.
And you were also reminding him of the limitations of the pursuit policy, correct?
What do you mean?
That you can't just get into a high-speed car chase or shoot up a car without specific reasons, right?
Yes, our pursuit policy limits what we can pursue for.
And a gross misdemeanor warrant doesn't qualify for a vehicle pursuit, right?
Not according to our policy.
And you had just reviewed that policy with Officer Lucky that day, correct?
Yes.
So getting to what happened with the stop, you said that there was a turn signal misplacement, perhaps. You saw the wrong turn signal. That was the first thing that you saw?
Officer Lucky saw it first.
Okay, so you didn't see the wrong turn signal. But after that, you saw the air freshener, right?
I saw the expired registration.
Well, you had said on direct that you would not have pulled that vehicle over, right?
Probably not.
And you said that you knew that there had been some delays because of COVID with people getting their tabs up to date, right?
Yes.
But you also mentioned the air freshener to counsel on direct, didn't you?
Yes.
But regardless, expired tabs, air freshener, this is the kind of traffic stop that is pretty routine for you in your 26 years as a cop, right?
No traffic stops routine, but it would have been something I would have done several times.
I'm sure you've seen lots and lots of cars with air fresheners and expired tabs. True?
Yes.
And then the decision was made to pull over the car. You mentioned that there was some information that maybe there was some other warrant that you learned about around that time. You didn't discuss any of that with Officer Lucky, did you?
He would have had the same warrant hit that I would have heard.
None of that was mentioned. None of it was even worth discussing with Officer Lucky at the time you pulled over the car. Fair?
I don't remember if we talked about it or not.
Okay. But in any case, you pull over the car, and Officer Lucky approaches the driver's side, approaches Mr. Wright, right?
Yes.
And he came back to the car with a name, date of birth, all kinds of information, right?
I know a name and a date of birth.
Well, Officer Lucky told you that he believed him. He thought that essentially that Mr. Wright was telling the truth, right?
Yes.
And then when Officer Lucky put in all this information into the system, you corrected him, you admonished him, you told him he was doing it wrong, right?
I told him better ways to do it, probably.
And that's your job as an FTO, right?
Yes.
To correct him if he messes something up, right?
Yes, when there was an opportunity.
So you corrected him, and then he re-entered the information, and then you found out about the warrant, right?
Yes.
Now there was also a conversation about Officer Lucky code 4ing himself, right?
Doing what?
Code 4ing
Oh,
himself.
code 4ing, yes.
And did you also correct Officer Lucky for doing that?
He did it before he ran the driver, and he shouldn't do that.
And you told him that, right?
Yes.
Don't code 4 yourself before you have all the information. Something to that effect, right?
Yes.
And again, that was your job as the FTO to correct whatever he was doing that was wrong, right?
Yes.
So you got this information and then made this decision to go arrest Mr. Wright, correct?
Yes.
And you didn't talk about going out there with guns drawn or anything like that. You didn't talk about using force on the approach or anything like that, right?
No.
And then Officer Lucky pulled or asked Mr. Wright to get out of the car, which he did, right?
Yes.
And you stood back and watched this happen, correct?
I was just a couple feet away.
Okay. But you didn't correct the way that had happened. You didn't tell Officer Lucky to move or to put Mr. Wright somewhere else, right?
I wouldn't do that to a rookie in front of a suspect.
Okay. But you didn't do it in regardless. Didn't happen.
No.
And then as you approached and got closer, was there a moment that you got closer after things didn't quite go the way you had hoped they would go?
I got closer before that happened.
Okay. And you'd agree that you unsnapped your gun holster as you approached, right?
No, I wouldn't agree to that.
All right, if we could put on the screen Exhibit 12, just the still image at 2:01:20, please. And zoomed in on, yes, the squad car view. You see yourself in that picture,
Yes.
and you see your right hand on the right side of your duty belt.
Yes.
And it's your right hand on your firearm here.
It's blurry, but it's possible.
Okay. We can take that down, thank you. All right, so as you approached and Mr. Wright got out of the car, was there a moment where it appeared that Mr. Wright was going to flee or attempt to flee?
When he started struggling with Officer Lucky.
Okay. And ultimately, was Mr. Wright able to get back in the car?
Yes.
You never saw a weapon on Mr. Wright, did you?
No.
Never saw a gun.
No.
He never threw a punch, right?
No.
Never kicked anyone.
No.
Never said, I'm going to kill you.
No.
Never said, I'm going to shoot you.
No.
Never said, there's a gun in the car and I'm coming after you.
No.
Okay. It's not uncommon in your experience to find someone who has a warrant during a traffic stop, right?
It's not uncommon.
And you've done hundreds of traffic stops in your career, correct?
I don't know if hundreds, but yes, I've done plenty of traffic stops.
And gross misdemeanor offenses are not the same as felony offenses. Fair?
Correct. They're different order by the judge. For
Less
the crime.
serious crimes, correct?
All crimes are serious, but yes.
Well, in terms of the laws of the state of Minnesota that you're duty bound to enforce, a gross misdemeanor is a lesser offense than a felony, correct?
Yes.
And you don't get to shoot someone because they have a gross misdemeanor warrant, correct?
Not for.
Your Honor, it depends on the circumstances.
Okay, but the objection is sustained.
As
The
the
jury
jury
will disregard that question.
You also testified about learning about an order for protection, correct?
Yes.
You said it was a temporary one that you saw, correct?
I believe it was an ex parte order.
And essentially, the order that you're describing would limit contact between two people, correct?
Yes, in various ways.
It doesn't prohibit all contact with all members of the opposite sex, right?
Just certain parties that they're not supposed to have contact with.
Right. And you'd agree that half the world's population is female, right?
I suppose.
So just having a female passenger in your car is not in and of it and by itself a violation of an OFP, correct?
It has to be investigated.
Sure. And you did not see a need to rush up to the passenger side of the vehicle and pull this woman to safety, right?
Not at the moment.
Okay. Now, there was also some conversation, as you saw in the videos that were offered in court in this case, conversation about the Wright brothers. You made a comment about the Wright brothers joking about not the ones that fly, right?
Yes.
And then any concerns about whether there was some other Wright family in the area, Sergeant Johnson told you not that family, not this situation, right?
I wasn't sure who they were.
Okay. But he didn't cause you any greater, he didn't tell you this is the family we should be concerned about. We got to be worried about this guy, right?
No, he didn't say anything like that.
Okay. And when you got over to that car and Mr. Wright got back into the car was still running, right? It was running that whole time?
I don't know if it was on or not.
Well, you told Dr. Miller that the car was running, didn't you?
I don't remember that.
You told Dr. Miller that Wright pulled away and got back into the driver's seat of the car, which was still running.
Okay, then I said that.
And the entire time this is happening, you're standing behind Officer Lucky, right?
At what point?
As Mr. Wright is getting back in the car.
I came around Officer Lucky's left side to help him.
And you indicated that Sergeant Johnson had approached on the passenger side, but he wouldn't have been in front of the door because that would have been unsafe, right?
Yes.
Okay. I am going to put on the screen Exhibit 13, starting at 2:01:48. Just that. If you could just leave it with that time frame, please. Okay, Ms. Potter, on the screen we have Exhibit 13 at 2:01:48. I'm going to slowly advance the frames and then pause it periodically. So let's advance just a bit. Okay, stopping right there. At 2:01:48, do you see yourself here taking a piece of paper in your left hand?
Yes.
All right, now advancing to 2:01:49, please.
Tim Blotz here in the Fox 9 newsroom. We want to welcome you back to our live streaming coverage. Judge Chu is now back in the courtroom where she and the attorneys are going to start going over the jury instructions to be read to the jury after closing statements that we now presume will take place on Monday. So here is Judge Regina Chu on the stand.
Say something, Mr. Gray.
What'd she say? He wanted to know if he could take his mask off.
I'm behind plexiglass. Okay. All right. If you're speaking, you could take your mask off. Okay. All right. All right. Let's go through this page by page. Okay. You have our most recent draft, the one Zach sent you. Anything on page 1?
No, Your Honor.
Page 2.
No, Your Honor. No, Your Honor.
Page 3.
No, Your Honor. Nope.
Page 4.
Yeah, right here. No objection. No, Your Honor.
Okay, page 5.
No, Your Honor. No, Your Honor.
Okay, now we're at page 6. Do we need a superseding cause instruction?
Absolutely. You got it in there.
It is in here. I was just wondering if it's at all applicable.
It is applicable.
Okay.
Well,
You don't.
We believe it's applicable.
what I understand the argument's going to be is that by fleeing, he's the cause. It can't, as a matter of law, be superseding of the
Right.
events. So, no, a superseding cause is not
That's
necessary.
part of the case. You can't mandate that it's not.
Okay, I'm going to keep it in, okay? Anything on 7 that you want to object to? This is okay. Now we're at 8, and I've changed down at the bottom. I've struck affirmative defense and just left it at defense. The jury's not going to understand what affirmative is or isn't. So it'll say defense hyphen authorized use of deadly force by a police officer.
You shouldn't put good defense in it? No?
The version I have, Your Honor, it does say affirmative, so you're taking that out. Since
We're taking out affirmative because nobody understands what that means.
that's fine.
All right. And I think the state wanted to be heard on my change to the standard instruction on the kind and degree of force. The standard instruction did not have the hindsight language, which is in the standard instruction for non-deadly force. Or has the state withdrawn its objection?
No, Your Honor, if I can just make a record about that, we did.
Sure.
Can you hear me okay? So the state's position, Your Honor, is, first of all, that the use of non-deadly force instruction should not be given. I realize we're not at that point yet. But the hindsight language, we oppose the inclusion of that. And so if we're looking at page 9 of the proposed instructions, that last full paragraph, there is a sentence about halfway down that says the reasonableness of the particular use of force must be judged from the perspective of a reasonable officer on the scene, rather than with the benefit of hindsight, taking into consideration split-second judgments, tense, uncertain, and rapidly evolving. I think we all are familiar now with that language. It's that language, Your Honor, that we feel the court should not include. Prior to that sentence, maybe I'm doing this backwards, is the sentence that says to determine whether or not the actions of the police officer are necessary, you must look at those facts known to the police officer at the precise moment she acted with force. We think that's appropriate, and that's an accurate statement of the law. All that follows is simply repeating that same concept, that, in other words, that we're limited to looking at what the officer knew at the time, and is unnecessary language, because that's already included in the instruction. That language is, we heard testimony from Professor Stoughton, and I think might have been Mr. Imes, or one of the trainers anyway, that explained that 20/20 hindsight language is about that very concept. You can't look at facts that occur afterwards. My central issue continues to be with this additional language that comes out of appellate decisions in immunity cases where the appellate court is essentially telling the lower courts, in granting or denying immunity, you can't be looking at these things that we know or learn later. And so their appellate language, I get it, they're an appellate opinion, and that's probably why they end up winning the jig. But the reason I think they're inappropriate for a district court jury instruction is because they have the force of the court's authority behind them, and they're singling out specific facts for the jurors to consider. And that's why that additional language is improper in addition to being unnecessary. It's just a way of saying, also consider these things. So in other words, when we have a jury instruction on impeachment, the court gives, hey, you could consider some of these things, but we don't go forward and say people who use drugs are not as reliable. You know what I mean? We don't use it, we don't tell them how to think about certain things. And that's what I think this language does and is improper. My feeling that what probably happened is the writers of the jigs saw that language in the opinion and included it. Our position is it's unnecessary and actually improper to add it. That is our objection to that language.
Okay. Mr. Ng.
Are we persistent in its inclusion? We had a discussion about this in chambers. This is consistent with Graham versus Connor, and we would prefer then ask you to keep this language in as it is.
Okay. Two things. First of all, the U.S. Supreme Court has specifically stated that this is an appropriate consideration in determining reasonableness. And number two, it is the standard jig for non-deadly force. And I'm just using the same standard in the deadly force instruction. So that hindsight language is already part of the standard jig for non-deadly force, but not for deadly force. There's no reason why it shouldn't be in the deadly force instruction. Okay. State's objection noted. And then number 10, at the top, the title should be use of non-deadly force, and strike authorize and strike defined. Then I like the state's suggestion on explaining this taser use. Did you get a copy of the state's?
Well,
Okay.
we did get a copy of it.
All right. They're saying, in this case, you have heard testimony about whether, first of all, is the state objecting to any instruction on non-deadly force?
We are, Your Honors, as we argued before, the only use of force at issue in the case is the firing of the gun, which clearly is deadly force, and so we continue to take the position that the jury should not receive an instruction on the use of non-deadly force.
Okay, and I've overruled that objection because the state's expert stated that the use of the taser was unreasonable and inappropriate. So the state's expert really made it an issue. So, Mr.
Well,
Ng?
yes. Well, have you read the state's proposal? We would object to the first sentence of the state's proposal and the last sentence, and then leave the balance of the instruction in.
Your Honor, I'm not going to argue that authorized use of non-deadly force is a defense at all. I might argue about it. Talking about Professor Stoughton, Mr. Professor Stoughton, but I'm not going to claim that it's unnecessary. I mean, if I do, are you going to instruct before or after the arguments?
Before.
Oh, okay. Well, then I can do it.
Okay, and I like the state's language. In this case, you have heard testimony about whether the defendant's apparent decision to use a taser was reasonable or appropriate. I think that's accurate. And I would go down to the statutes of Minnesota provide that a police officer is authorized to use reasonable force in the line of duty, period.
Now, we would like you to say in executing a valid arrest warrant.
Yeah.
Well, you are instructed that executing a lawful arrest warrant is a duty imposed on officers by law. That's so subparts 1 through 4 are just duplicative and confusing. So there'd be a period after line of duty, and we would strike 1, 2, 3, and 4 and go straight to you're instructed that executing a lawful arrest warrant is a duty imposed on officers by law. And then the standard instruction on reasonable force. And I also like the state's suggestion on the explanation. Whether the defendant's apparent decision to use a taser was reasonable or appropriate is not a defense to the charges in this case.
It's not an absolute defense, I think you should put, because the evidence is entered into this case, and this professor says that that was a violation too. So I just think that if you're going to comment on it, whether the defendant's apparent decision to use a taser was reasonable or appropriate is something you may not consider in order, well, leave it alone, I'll argue, no problem, Judge.
Okay.
So, that's it.
Are you withdrawing your comments?
All right.
Are we okay with the state's proposal then?
I'm in a state of confusion always.
What? The actual language, whether the defendant's apparent decision to use a taser was reasonable or appropriate, is not a defense to the charges in this case.
But I can't argue, Judge, that her decision was appropriate as far as she was concerned.
Yeah.
She testified to that.
Yeah. You can argue that she could use a taser under the circumstances.
I do have a question.
But you can't say that she's not guilty of either charge because the use of the taser was appropriate.
Yeah, but it shows circumstantial evidence that she was in good faith, that she wasn't intentionally doing anything devious.
Well, okay, you can't argue that it's a defense. You can't say she's...
I'm not going to argue it as a defense.
Yeah.
But I am going to argue that Mr. Stoughton said that in his incredible opinion, he said that even what she did with the taser was unreasonable and appropriate. Read the instruction about Mr. Stoughton's opinion, and I'll point to it. That's all.
Okay.
So are you doing in toto the state's proposal here? Are you substituting it all in? Or you just, help me with what you're doing exactly at the top. I may have missed it, and I'm sorry to indulge.
Okay. I am adopting the state's proposed language, the introductory language. So it'll say, use of non-deadly force. That's the title. In this case, you have heard testimony about whether the defendant's apparent decision to use a taser was reasonable or appropriate. And then the last sentence would be whether the defendant's apparent decision to use a taser was reasonable or appropriate is not a defense to the charges in this case.
Are you going to cross off the state's 1 through 4 sentences? I think you are. Am I right?
Right, 1 through 4. 1 through 4 is effectuating a lawful arrest, executing legal process, enforcing an order of the court, or executing any other duty imposed upon the officer by law. I mean, right under that, it says you are instructed that executing a lawful arrest warrant is a duty imposed on officers by law. Do you want additional language in there?
Well, we would like executing legal process, enforcing order of the court. I mean, what we asked for was the statute, 609.06, and the language of the statute should be...
Okay, we can put the... Okay, we'll put it... Oh, with all due respect. Okay, we'll put that back in.
That was probably
Okay, now, anything on 11?
Can I just make a record about this?
Yes.
All right, so I indicated before, I think, so it may not need repetition, but I will, just our continuing objection to have this instruction in at all. And I want to point out that we also, of course, have the objection to the hindsight language in the definition paragraph here, consistent with the court's other definition of it in the deadly force. And then, Your Honor, I should point out, that that paragraph is different as well, just so we're all clear about this, in the first line, where in the deadly force instruction, it starts out saying, as to each count and defense. Right? So do you see what I mean? In the deadly force instruction, that last paragraph starts out as to each count or defense. I did not include that in the non-deadly force definition so that there wouldn't be any confusion when we go on to tell them this isn't a defense, right? I just want that clear to everybody.
Yeah, I'm sorry.
So that, and then, Your Honor, if we're going to if we're going to reinsert paragraphs 1 through 4, I would ask the court to take out arrest in the next sentence. You are instructed that executing a lawful arrest warrant. All the testimony in this case has been that it was a bench warrant or a warrant, and so to call it an arrest warrant, I think it misstates it.
Judge, I just noticed, and I've had a few of these, what we missed here, and I walked by, at on page 7, on count 1 and count 2 both, at the end of them, if you find that each of these elements been proven beyond reasonable doubt, the defendant is guilty. If you find any element that has not been proven beyond reasonable doubt, the defendant is not guilty. In addition, if you find that the state failed to prove that reasonable force, you mean the language fall.
Well, once self-defense is raised, they have to prove it beyond reasonable. Prove she didn't act in self-defense beyond reasonable.
Yes. So that should be in here, because otherwise you say, well, the judge says if they prove these elements, he's guilty. But you got to warn them. Look at the self-defense or reasonable use of force instruction. And if the jury finds that it was reasonable use of force, they're not guilty. So you got to put in there that
once you raise the defense, they have to disprove it beyond reasonable.
Right. It is on page 10 at the top of the page.
You know, my argument is with the last paragraph of count 1 and count 2, where you tell them if the elements are proven beyond reasonable doubt, the defendant is guilty, unless the state whatever. You have to put that in there that the state has the burden of proof to prove that reasonable force. There's the language. Tell me how to call.
You're I'm sorry if I may.
It's in here.
At the bottom of page 8 is when the court's instructions start talking about defenses, it plainly says Minnesota law provides that no crime is committed and the police officer's actions are justified. And then, of course, as the court pointed out, at the end of the instruction, it says they're not guilty of a crime.
Mm-hmm. So it's in there. You're covered. Okay. All right, and let's go back. Let's go back to page 9, the last full paragraph. I'm wondering if the language that says as to each count or defense is confusing.
You don't think so?
Okay, leave that the way it is. Is what the defense says, right?
Yeah, we want it.
Okay. All right. I shouldn't have brought it up because everybody agrees, right? All right, where were we? Are we on page 11?
Well, and I think we're all done with the non-deadly force changes. I did ask, Your Honor, to have the court remove arrest between lawful and warrant in the non-deadly force instruction.
You know what? I'm going to leave everything in there. You know, I just tried to make this a little bit easier for the jury, but if the defense wants it in there, I'm going to leave it in there. Okay, are we on 11? Anything on 11?
No, Your Honor.
No.
Anything on 12? The implicit bias instruction is incorporated under duties of jurors. So 12 or 13?
Nothing from the state, Your Honor.
Okay. And did you have a chance to take a look at the verdict forms?
Yeah, I did.
Oh, okay, no objection to the verdict forms either, right?
They haven't changed at all since the last
No. Okay. Here's what I'd like to do. First of all, yes. Oh, I like it when you raise your hand. Okay. He raised his hand first.
Before we transition out of the jury instructions, the defense did request an instruction on policy, and we would like a ruling one way or another. The instruction that I requested via email, which I'd like to read into the record and get a ruling from you. Brooklyn Center police policies are not criminal statutes, period. An alleged violation of a policy is not a crime, period. And we requested that on December 14th, and the court deferred ruling. We do persist in requesting that, and if we would like a ruling one way or another from you at your leisure, but I do want to persist in our...
Okay, I forgot about that. Does the state object? I mean, it's true.
Yeah, it's true but unnecessary. You're defining the crimes for them, and very specifically telling them to find them guilty, you have to find these elements. And it's just not necessary, potentially confusing, to give them a specific instruction about policy.
Okay, I'm going to include it because it's true, and it's an accurate statement. Okay.
I'm sorry. We had requested some language be added to the instruction because it's not incomplete. I mean, it's not complete. And I'm trying to remember the exact, because I don't have it in front of me, but but it can be considered in determining, whether the defendant is guilty, because that's also true. Right? It is evidence in the case, and so.
I'm not going to talk about that. You can't consider that in determining whether she's guilty or not guilty. Plus, I don't know what we're arguing about. The Brooklyn Center policies are consistent with the law. So I'm not going to add that additional language, but where would you like that put in the jury? Where do you think it fits?
Right after page 5, after demonstrative evidence, charges are consistent. Like that. Fine.
Okay, we'll put it on page 5. Right after demonstrative evidence. All right.
What would the title be?
Oh, yeah. What's the title?
Falling. Evaluation of policies.
Consideration of policies?
Consideration of policies.
Okay. Consideration of policies. Okay. I'll make the changes and recirculate another copy. We'll do it in 14 inch, okay? So, and if you notice anything at all, any typos or anything, let me know by no later than 4 o'clock, okay? And let's see. Oh, would the defense take the time, please, to look at the thumb drive on the computer that the state has? That because there's a computer, a laptop that's going to go to the jury room, right? And then there's that thumb drive with all the exhibits on it. So I want the defense to stay and look at all the exhibits so that you can confirm that all the exhibits that were entered are on the thumb drive, and check out the computer, the laptop, to make sure that it's clean of any other material. The laptop that goes back with the jurors will not have internet capability. Okay. And then tomorrow morning, I just want to put on the record that you've had enough time to look at that, look at the thumb drive exhibits to make sure that's appropriate, and that you've also had a chance to take a look at the laptop and make sure that it's appropriate to go back to the jury room. So we'll make a record of that tomorrow. And oh, that's okay. Oh, yeah. We'll do it Monday. Okay. I misspoke. Okay. Yeah.
I had just circulated an email to everybody about the 2 defense exhibits. We need to get electronic copies of those to put on the. You're on that already?
I sent you our 2 electronic
Did you?
exhibits. Yep.
Okay. And then we try to keep track of all exhibits that were received, and I, of course, would like to think we are flawless at that, but I would rather seek some corroboration. So if the court has an exhibit list, I'd like to kind of cross-reference ours with theirs, with yours, and then once we do that, we can dump all that onto the electronic stuff we need to.
Okay. Yeah, Mr. Kramer's going to help you with that. Okay, what else? I think that's it. All right, Counsel, I just want to tell you that I've really enjoyed having you. It was a really well-tried case on both sides.
I kept making those long objections, Judge.
You can't help yourself, can you, Mr. Gray? All right. Okay. Have a relaxing weekend if you can.
And there you have it, day 8 of the trial of Kim Potter for manslaughter 1 and 2 in the death of Daunte Wright from that traffic stop in Brooklyn Center, suburb just north of Minneapolis here this past April 11th. Day 8 now wrapping up. Kim Potter takes the stand in her own defense today. You had a chance to hear it live here on our stream on fox9.com and our YouTube channel. We are going to reconvene courts again on Monday morning at 9 o'clock Central Time. We will have the stream up and running at about 8:50 with myself and my colleague Paul Bloom, where we fully expect to begin the closing statements in this case, and then it goes to the jury. So thank you so much for tuning in today. Have yourself a wonderful weekend, and we will rejoin you at about 8:50 on Monday morning. On behalf of everyone here at Fox 9, thanks for joining the stream. We'll see you again soon.